Good morning, everybody. As I clear my throat to get things started, happy Wednesday. Welcome to TCF Live. My name is Dan Soul. I will guide you on a 3-hour journey through Courtlandia, starting at the St. Joseph County Justice Closet. This is Judge Middleton.
From the prosecuting attorney's office. Mr. Long is charged with domestic assault. It's alleged that on April 13th of 2026, he made an assault upon Arlie Lillian Noel James. Yes, I'll start again. Thank you. And push the on button. There we go. All right, we're here in the matter of People versus Vance L and Long. File number is 26650SM. This room's a little disconcerting. You got to turn this way to see the screen, and the parties are out here. Anyway, this is the time and date set for a jury trial in this matter, but there have been some developments. The allegation is that on April 13th, he made an assault upon Arlie Lillian Noel James, an individual he had a dating relationship with, that allegedly occurred in the city of Three Rivers. Mr. Long is here with his attorney, Mr. Ross Trucking. Also present is Angelique Canfield from the prosecuting attorney's office. This matter was the only case set for jury trial today. It was set after our last pretrial. And several weeks ago, Prosecutor Stoll and Mr. Truckee discussed the matter, and Prosecutor Stoll asked for an adjournment because she was going to be unavailable. Well, I said, well, can't we get someone else to at least address this and see if we could either try it or resolve it? So to Ms. Canfield's credit, she picked it up, looked at it, and said, all right, let's see what we're going to do. She had indicated that the prosecutor had served the complaining witness, but had not had an ability to discuss the case with the complaining witness. She wouldn't return phone calls, and her message was full on her phone. So what we agreed to do is that we would leave the matter on for hearing. We would not summon the jury or the police witnesses. The defendant would be expected to be here, and if the complaining witness honored her subpoena, she would have an opportunity to discuss the matter with the prosecution. So as I understand it, the complaining witness is here. Mr. Long is here with his lawyer, but no jury is here. We're not going to have a trial. And I've bemoaned losing the date, but apparently we've not resolved the matter. Ms. Canfield, what's the status here?
I have had an opportunity to speak with the complaining witness, Your Honor, and I've made an offer of plead guilty to domestic violence under this 769.4 deferral statute with a no jail upfront recommendation. That offer has been rejected. It will not be renewed. We will not agree to any deferral in the future. This defendant has 2 juvenile convictions for domestic violence against the same victim. And as the court is already aware, violated bond on this particular matter to have a physical altercation with her again. So I will not be recommending that again if the plea is not entered today. And additionally, I will be requesting upfront jail given his juvenile record. If there's a conviction at trial.
Now let's unpack this. You're charged with domestic assault. That's a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. You're eligible for the deferral under a special statute, 769.48. The deferral would mean I would put you on a probation, and if you successfully completed the probation, the charge would be taken off your record as a public record of conviction. I can only do that if the prosecutor agrees. I can't do a deferral without the prosecutor's consent. If you are convicted, you'd be prohibited from using a firearm or possessing one for at least the next 8 years. You'd also have a criminal conviction on your record for domestic assault.
Yes.
Deal with it. You have done, I think, 1 day the night you got arrested, and then you did 3 days for the bond violation. So you've done at least 4 days in jail so far. Prosecutor recommend no additional jail up front if you comply with the terms of your probation. So that's a pretty standard offer. They've had an opportunity to discuss this with the complainant. The fact that you have juvenile convictions for the same thing may go to what the sentence would be, but they do not prohibit you from getting a deferral. Mr. Truckee, have you had an opportunity to discuss that with Mr. Vance?
Yes, sir.
Mr. Vance, you don't wish to avail yourself of that deferral probation option, no additional jail? All right, the prosecutor's offering no additional jail time and a probation that will allow you to take this charge off your record. And that seems appropriate on the facts. They've got the discretion. They've had a consultation with the complaining witness. She's apparently prepared to testify, and we could move forward. If we hadn't had all the glitches we had, we could have had a jury trial today and have the jurors decide this. At any rate, if you don't plead to this charge, the prosecutor is not going to agree to a deferral. So if you're convicted, it will go on your record. If you are convicted, they're going to ask for additional jail time. So by their plea offer, they're agreeing not to ask for any jail time and allowing you to do a deferral. That would resolve the case. I would place you on a probation. I would allow you to comply with the terms of probation. So let's talk about what probation would entail, rather than some nebulous idea about what it is. If I did put you on probation, I would prohibit you from having any assaultive or threatening behavior. I would ask you to either do the domestic violence treatment class or the anger management class. In this case, it probably would be the full domestic violence treatment class. If she agrees, I would allow contact. I would lift the no contact provision, which would allow the two of you to have contact as long as you didn't have any assaultive or threatening behavior. You'd also be prohibited from using any alcohol or controlled substances. So you wouldn't be facing any additional jail time. You'd allow a deferral, and you'd be allowed to have contact with her as long as she's agreeable with that. You understand? All right, so if you pled to that charge, the case would be resolved today. I would place you on a probation. Hopefully you would comply with the terms of probation and eventually have the charge taken off your record. You don't have to do that. You have an absolute right to plead not guilty, and you have a right to have a jury trial. The problem is we squandered today's date. It may be some time before I can set this for another trial. But she's here. If you do plead, I probably can do the sentence right now. So that's the options. If you plead, I would place you on probation, follow the prosecutor's recommendation for no additional jail time. If you wish to continue your plea of not guilty, we'll reschedule this for a jury trial. You understand? All right. After having heard all that, does that affect your decision about what you'd like to do here today? Do you want to take a minute and talk with your lawyer about this? Yeah, why don't you guys step out? I gave you a lot of information you didn't have. All right, I'm going to stop the live stream.
Alrighty, he's stopping the live stream, but I'm sure he'll pick it back up when they come back, so we'll check back in. Good morning once again, everybody. It is TCF Live on a Wednesday. It is so good to have you with me here today. And I mean that. This is like the coolest thing I have done in my life. Well, not the coolest. You know, like married to a good woman and all. But it's up there, so thank you. Let's Lenawee County. Judge Anzalone. Say good morning to her.
Can you hear me?
Yep, I can hear you.
All right, excellent. This is file number 2024-1983FH in the matter of the people of the state of Michigan versus Christina E. Edmonds. This is the date and time scheduled for request and summons for probation violation. So, Ms. Edmonds, it is alleged that you have committed several technical violations of your probation. One is that they allege you failed to report as instructed in the month of July. The second one is that you failed to enter residential treatment as instructed on or about June 22nd of 2026. The third is that you have not attended outpatient treatment as instructed since on or about June 23rd of 2026. And the last one is that you failed to submit to drug testing as instructed for the month of July. So those are the allegations against you for a technical violation of probation. You are currently on possession or on probation for a controlled substance possession less than 25 grams. So if you were to plead guilty or be found guilty, you could be facing up to 4 years in prison. Now, Ms. Edmonds, you do have a right to have an attorney represent you on this and all subsequent hearings. If you can't afford to hire one, we have an attorney you can speak with today. So would you like a court-appointed attorney?
Yeah.
Your Honor,
Okay.
I believe she already has me.
Yeah, I do.
I don't know, but okay. Do you need a breakout room with her?
Really, Your Honor, I don't. I'm in possession of a letter from this Lindsay Bucking or from Olivia Jackson at the Salvation Army, Your Honor, giving an update on Ms. Edmonds' treatment. I believe the probation department also may have that. So I would just like to enter a not guilty plea on Ms. Edmonds' behalf, Your Honor, and see where we end up with this.
Is she an inpatient program?
She completed a residential treatment program and she remained through August 6th, where she successfully transitioned. I have the letter. It's right. I can bring it into you, Your Honor.
Okay. And did that go to the probation department, Ms. Walsh?
We have it, Judge. We have the letter.
Okay, so Ms. Underwood, what I will do is I will set this out. I'll enter a plea of not guilty and I'll set this out to, and Ms. Rogers, I know this isn't your file, but do you have any objection to me sending this out to like September 16?
No, Judge, that's fine.
And in the
Right,
meantime,
so-
Ms. Edmonds, report to Ms. Walsh.
Okay.
Right, so Ms. Edmonds, I'm going to set this out to September 16 at 8:30 in the morning. Continue to report to Ms. Walsh, test, and do everything you're supposed to be doing, okay?
All right. Thank you.
All right, thank you, Ms. Edmonds.
Yeah.
All right, Erica Benson, if you could unmute your device, please.
All right.
Ms. Benson, can I ask what case you're here for?
The right.
Oh, hold on, Ms. Benson, hold on a minute. Hi, this is Judge Anzalone again. I am ready for Israel Vila as well.
Okay, sounds good.
All right, thank you, bye.
Bye-bye.
All right, I'm sorry, Ms. Benson, can I ask what case you're here for?
I believe it's the right. Erica Wright.
Yep, okay, so that is the date and time set for a pretrial. You're just here to watch the proceedings?
She's on the docket.
Oh, your name's Erica Wright.
Your Honor, that's her.
Yes.
Okay, well, her screen says Erica Benson. That's why I was asking. Okay. All right, I'm sorry. All right, here we go. So this is file number 2026-22678 FH in the matter of the people of the state of Michigan versus Erica Lynn Wright. Ms. Underwood, I'm assuming that means you represent her, correct?
I do, Your Honor.
All right, so this is the date and time set for a pretrial conference. I do have a letter from Darren Coast dated August 10 of 2026, stating that Ms. Wright has not been testing due to medical reasons. I'm not going to go into that. We do have verification from U of M and Chelsea Hospital. That going forward, we can just have her come to court hearings in person and test her when she's here, just to alleviate those other issues that we have. So Ms. Underwood, how would you like to proceed with Ms. Wright?
Your Honor, I talked to Mr. Coast yesterday afternoon, and we agreed, and I hope the prosecution will agree, that perhaps to put this out for a month or two until Ms. Wright feels a little better. She's had some medical issues, would be appropriate.
Mr. Bandetto, are you the prosecutor?
And I'm happy to do the stip to adjourn.
Okay, Mr. Amadeo, is this your file?
I'm sorry, Judge. Is this Stella Garza?
No, Mr.
Okay.
Bandetto, I'm sorry, Mr. Bandetto, is this your file?
It is, Your Honor, yes.
All right, did you receive the email from Mr. Coast? I don't think we typically send it to the prosecutor.
I did not know.
All right, Mr. Coast, would it be possible to get a copy of your letter to Mr. Amadeo or Mr. Bandetto so he's aware of what's going on?
Absolutely, Judge.
Okay. All right, so Ms. Wright, I'm going to adjourn this out to September 16 at 8:30 in the morning. I'm going to ask that you come in person. So just to save you from having to do the testing like we normally require, I'm going to have you come in person and you can just test while you're here. Okay?
Yes.
Okay. And we will see you back on September 16th at 8:30 in the morning. And Ms. Underwood is going to do the stip in order. Mr. Bandetto, can she sign your name with permission?
She can, thank you.
Okay. All right, excellent. Thank you. So Ms. Wright, you are all set. Just remember, going forward, come in person, okay?
Thank you.
All right, thank you. So many people. All right, Randall Lambert. Let me grab your file. Okay. All right, this is file number 2026-22513FH in the matter of the people of the state of Michigan versus Randall Allen Lambert. This is the date and time set for a violation of probation arraignment. Mr. Lambert, it is alleged that you violated the terms of your probation. And then on or about August 10 of 2026, you engaged in assaultive, abusive, threatening, or intimidating behavior toward Jennifer Ellis Berger. The second allegation is you violated the terms of your probation and that you had prohibited contact with this individual. And it's alleged you violated a term of probation that you failed to enroll in a domestic violence program. So you are currently on probation for felonious assault, which carries a maximum penalty of up to 4 years in prison. If you were to plead guilty or be found guilty, it's my understanding, Mr. Lambert, you do have some pending charges. You do have a right to have a court-appointed attorney. I know that you qualify for one. So would you like an attorney appointed to represent you?
Yes, I do.
All right, and Ms. Underwood, you have already reviewed the file and you're the one that informed me that there are some pending charges. Is that correct?
Yeah, I was just going to explain that to him, Your Honor. He does.
All right, so Mr. Lambert, because you have pending charges stemming from these allegations on the violation of probation, I'm I'm assuming Ms. Underwood's gonna ask for an adjournment on this to see what happens with those new charges. Is that correct, Ms. Underwood?
That would be correct, Your Honor.
And
Mr.
how
Lambert,
far out?
I'm happy to talk to you for a second, but that is correct.
How far out would you like an adjournment, Ms. Underwood?
I would say 2 weeks, Your Honor.
How about September 2nd? All right, so I'm going to adjourn this out to September 2nd at 8:30 in the morning. And Mr. Lambert, we'll see you back on that day. I'm assuming in the interim, you're going to be arraigned and court dates set on these new charges so that your attorneys can figure out what's going on there. And we do the notice because it's a bot. So you're all set, Mr. Lambert. Thank you.
Just for the record, Your Honor, I'm asking that the court enter a not guilty plea on Mr. Lambert's behalf.
Thank you.
Judge, can I ask what bond is set in this matter?
I believe I set his bond in the 25,000 cash. Sorry. All right, there we go. All right, you're all set, Mr. Lambert. Okay. Let's see. I have somebody in jail Zoom 3. Can I ask what your name is? On the wall behind you, it has a 3. Cody Gage. All right, let me grab the file. All right, this is file number 2024-21921FH in the matter of the people of the state of Michigan versus Cody Wayne Gage Sr. This is the date and time set for a show cause in this matter. Miss Sarabia, I really apologize. I'm gonna pop you in a waiting room for just a minute because we're getting a lot of background noise from the first floor, and I'll bring you right back. So, Mr. Gage, it is alleged that you have violated the terms of your probation, that you consumed intoxicants on or about August, or no, this is a bond condition, right? No.
Correct, Judge.
Oh, it's a bond condition. All right, so it's alleged that you violated your bond conditions and that you consumed some type of intoxicant on or about August 11 of 2026 and registered a .027 BAC on August 11 at 8:24 a.m. That you registered a .02 BAC for Pretrial Services Coordinator Darren Coase that same morning at 8:52. And you told probation officer Tom Moore that you had consumed vodka and orange juice earlier. So those are the allegations against you, Mr. Gage. A violation of probation can carry up to 93 days in jail as a contempt of court. And it can also result in a change in your underlying bond conditions. Now, you have Mr. Daly and Mr. Mott. Is that correct, Mr. Gage?
I think I have Mrs. Underwood.
Your Honor, this is a violation of probation that was set for September 30th. And now we're here on a bond violation.
So, Ms. Underwood, how would you like to proceed? How do you want to proceed? What do you want to do?
Well, I would ask the court to, well, first I want to talk to Mr. Gage.
So, Mr. Gage, I'm going to change your screen name. And I am going to then open up a breakout room for you and Miss Underwood and I forgot me. Sorry about that. All right. So I'm going to pop you two in a waiting room and then.
And Judge, mine is actually it's a show cause. He's actually in on a parole detainer after he registered numbers. Tom Moore elected to have him lodged.
Okay, so this is a show cause and there's nothing holding you in jail on mine. All right, so Mr. Gage, you and Miss Underwood join that breakout room.
But he's in on a parole detainer, Darren?
Correct. Yeah, but mine is just a show cause.
Okay.
Alrighty, good morning once again, everybody. It is TCF Live on a Wednesday. Let's go back to Judge Middleton. The defendant has re-entered the justice closet. Let's pick up where they left off.
I feel that she's aware if the complainant is all right with the
Oh, that I did not discuss with her.
I'll find out. All right, let's see if we can get this right this time. All right, we've returned to the matter of Vance L. Long. Mr. Long's had an opportunity to discuss this with his attorney, and at this point, he's indicated he's going to enter a plea to domestic violence, first offense, and accept the prosecutor's plea offer of no additional jail time up front and a probation with the opportunity to have the charge removed from his record. Is that correct, Mr. Long?
Yes, sir.
Do you understand that if you do plead to this charge, you'll be giving up your right to have a trial in front of a judge or a jury? There will not be a trial. Do you understand that? If you had a trial, you'd have the right to be represented by an attorney. Mr. Truckey's been here with you at every step of the way and will continue through a trial. He was ready to go today if needed. Could also hire an attorney of your own choosing if you wish. If you had a trial, you'd have the right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand and testify on your own behalf, but you don't have to because you have a right not to testify, and they can't take that away from you. And if you didn't wish to testify, the judge or jury could not use the fact that you didn't testify against you. Finally, you always have the right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. So let's talk about this. In April, you were living on North Lincoln Avenue, is that correct?
Yes, sir.
And Miss James lived there with you also?
Not legally, yes.
But he's kind of been on and off. She was staying there. Was she there on April 13th?
No, she was there.
Did you and her get into an argument or incident sometime that morning?
Yes, sir.
Tell me what happened.
So, then I woke up, I was watching TV. She had woke up, angry because I was awake still. She had went downstairs to use the restroom, but I went upstairs to use the restroom. Came back upstairs and she was more angry at me. It's kind of just, I don't know, I wasn't really picking up what she was saying, but I could just hear that she was talking a lot. Just that she was very upset.
Could I ask you to speak up?
Yeah, I'm sorry. I could tell that she was very upset with me. And so I told her that I think it would be smart if she just left. And then she, so, well, obviously, she was angry because it was full of more. She should leave.
Well, did you end up hitting her or pulling her hair, or did you put your hands on her?
My hands did end up on her, but not,
She ended up with a scratch on her face. She had a scratch on her left wrist and her face was red. Tell me about that.
Yeah, I don't know what happened with that, but,
If I could, Your Honor,
Yes,
did she gather up some of her belongings in preparation to leave?
yes, she did.
And did you believe some of those were your belongings?
So,
And did you snatch something back from her?
not directly from her, but from, the church.
Was that in her hand? Was that trash bag closely associated with her, the way she was holding it?
all right, and could she have gotten a scratch on her wrist while you were pulling that away from her? You know how she got the scratch? All right, so you said you put your hands on her. How did that happen?
So when she talks, um, and so there may have been a point where she put her hands down.
I say may have grabbed her by the hands. Could she have gotten a scratch on her wrist from that?
No, I didn't grab her. I just kind of gestured her, not gestured her.
All around thin ice here.
I don't know. It's fine.
We got, you snatched something out of her grasp, I guess could get us where we need to be. Ms. Canfield, are you satisfied with that?
I think it's severe minimization when I have a victim who reported being struck in the face multiple times.
Yes.
Somebody cannot benefit from probation if they cannot admit the behavior. But I do believe that the grabbing out of the hand is sufficient.
All right, yes. We have an agreement, but I tend to think the same thing. I think more happened here than what you're stating. But what you've related is enough for a domestic assault. You and she were in a relationship, you're in the same house, touched her, and you snatched something away from her, which is sufficient. She says you hit her in the face and have in the past. But we've got a plea agreement in place. I'll accept your plea, or I still need a domestic violence judgment. Ms. Canfield, I'm gonna give you a minute. If she's willing to come up here, we can bring her right in here. If she is not, would you at least inquire whether she has any objection to lifting the no contact provision?
Yes, of course.
All right, thank you.
I can hardly hear you, Doctor.
I need a domestic violence judgment.
Okay, I'm just gonna break it. It's like whispering.
Oh.
So we're not gonna be on that.
I thought I put some register of actions in here. Judge Patterson has his desk set up completely differently than I do. I think I'll just use paper and then I'll transfer it.
I apologize, I'm getting a change.
Can I have some ROAs too? I thought I put some in here.
As we wait for Judge to use words again, I would like to remind all of you that are watching out there that you can also watch using TCF Court Watch. You can find that at tcfcourtwatch.com, and it's made for moments like this. Because not only do you get the YouTube feed, the chat, and all of that, but you get all sorts of context and specifically several games that you can play to keep you busy during moments when the court is a little quieter than what we normally like to see. So again, tcfcourtwatch.com. Check it out. Totally free. Something that we do a little extra here for you. Yeah. All right. Use some words, Judge.
Normally, the law requires that I adjourn the matter at least 10 days between the time of conviction and the time of the sentence to give an opportunity for victim input. In this case, the complaining witness is right here, and we can either get her input or hear from her, so we can actually accomplish the sentence. There is a sentence recommendation plea agreement, which I've agreed to follow. So I think that today would be a good day to do the sentence if we can do it. Judge Pattison is quite busy with arraignments today. He's got like 22 or something. If I'd had a jury trial, he would have been doing that all in this little room. So I have this, and we have a no contact violation from an inmate that's in jail. We're gonna do that at 10. We may even just do it sooner while everybody's here. And
She does not wish to speak at sentencing, but she does not wish the no contact lifted. And I have been provided information that it was violated yesterday. So there's gonna need to be strong information from the court and direction that that's going to remain in place, I guess.
all right, I'll leave it in place until such time, if ever, she's willing to lift it.
You understand that means?
All right. You're gonna end up in jail again if you already did 3 days. Let's talk about this. I'm gonna do it. 12-month probation.
If I could inquire, Mr. Long, this is odd, we kind of had not quite a Cobb's, but a Cobb's in this case. Does the fact that the no contact order will be remaining in place change your desire in how to settle this case?
Sort of.
Would you still like to proceed with the plea and the deferral? With probation?
I feel it's so not just go through this program, get a few more tools for clicking.
All right, that's a good answer.
Very good, thank you.
All right, thank you, Ross. That's probably appropriate. All right, you've done 4 days. I'm gonna order 24 days jail credit 4. Of the 24, 20 days are deferred. So you're not gonna do additional jail time if you follow the order. If you don't, you're subject to at least 20 and maybe up to 93. The fine is 0. There's a $75 crime victims' rights fee and a $50 state minimum fee, $150 attorney fee. Mr. Truckee certainly earned this fee. That doesn't cover nearly the cost of the attorney. It's just portion that goes back to the county. 180 probation oversight fee to pay for the class. You told me before, but I forgot. Where are you working?
I've actually quit that job with Precision Wire.
I thought you were working in school crafts or somewhere. So you're not working right now?
I'm not. I was looking for a job, but I couldn't find one. And then a week ago or so, I just had a realization that it was today, and I don't want to commit to somebody else's family.
All right, well, now we know
We
know where we're headed. So, one of the conditions is I want you to get full-time employment.
Yeah.
Total is 755. Did post a 2010% bond, so 180 is subtracted from that because we'll apply your bond to it. 575. Anything less than 12 months, you complete the probation, you'll save $40 a month. I want you to do the DV class. You're gonna pay for it. No alcohol, no drugs, test as directed. This is the important component. No assaultive or threatening behavior toward the complainant. No contact remains in effect. Now, if at some point she wishes to lift the no contact condition, I could do that. But I don't want you writing her a letter and saying, hey, please lift the no contact. And if there's some vague allegation that you violated the condition yesterday, don't say anything. If you violate it, I'm gonna lock you up, maybe for 93 days. So right now you need a timeout. The prosecutor alleges there were a couple of incidents when you were a juvenile, she was assaulted. She says, Long hit her in the face multiple times. Long punches her often, but never hard enough to bruise. So you just said something. You need to do something to get some tools to deal with this. And I think you're right on the money. I think you need to deal with this. It's not just anger management, it's domestic assault. You guys have apparently been together since you were juveniles. You don't have a child together, but you have a relationship that's got some time to it. I want you to get full-time employment. How are you paying the bills?
So far, I've paid them in my parents.
Who owns this house on Lincoln? Okay, so you don't have a landlord breathing down your neck. Your parents live at that house?
Yes, sir.
All right, so you and Arlie were living with your mom and dad?
We're staying with my dad.
Okay.
Yes, sir.
Where is she staying now? Which is where?
Riverside.
All right. She may be off book, which may be causing some problems for her mom at some point. I don't want anything bad to happen. I don't know whether you guys can make this and live happily ever after. Or you're each gonna go your separate ways. But what I don't want what happened in the car at Wendy's when you ended up in jail for 3 days. I don't want this. I don't want anything else. I don't want letters. I don't want texts. I don't want Snapchats, Instagram, Facebook Messenger, nothing. You're not to have any contact with her. If she wishes to change that, You can do it in stages. We can do something that allow you to have contact but not live together. Or we can just lift it all together. You're not on bond, you're now on probation. So it's an order of your probation that you not have contact with the complaining witness. It's helpful that she was here. She did agree to this plea agreement after consultation with Ms. Canfield. As I indicated, I think more happened than what you said. And you need to get into the domestic violence program with the intent to make it work. What other kind of work have you done before you worked at Precision Wire?
I haven't really done any work.
How old are you?
20. I did work at American Axle for a little while through different company, PTI.
I think maybe that's what I was thinking about. Would you like to get back into American Axle?
I spent 20 weeks focused during doing the Michigan Job Challenge program, studying robotics and electrical trades. And I've been really finding to do besides Precision Wire. And story with that is I went to ask for a day off and the manager told me I wasn't doing enough for the company. So that day I decided we just show them what to do. So,
Well, you need to grow up. That's not your fault. But you're entering the adult world sometimes a lot harder than not. You've been polite and respectful to me every time I've seen you. This behavior here troubles me. But what I want you to do is I want you to follow the terms of this probation. I've put hundreds of people in this class, and almost every single one of them has said, I liked it. I bet they were like, you're a jerk. My lawyer's a jerk. The prosecutor's a jerk. I said, what'd you think of the class? Well, I like that. So that's what I want you to do. It's going to help you be a better relationship partner, a more mature young man, and you're going to come out of this better than you came in. If you don't, you're just going to be in jail for a while. And think about when you get out. All right, I'm going to send you out to the counter, and the probation department will come over and talk to you about this deferral. Let me repeat, you're going to get as much out of this program as you put into it. And I think it is going to be beneficial. I am glad, Ms. Canfield, I appreciate your help. We got this case over the finish line. Mr. Truckee, you as well. Now we'll start to worry about the 28th of August. We got 2 DVs on that date, Long and Simon. So I'll worry about our next jury date 2 weeks from now. All right, you go with the court officer, and you're free to go.
Thank you, Your Honor. Thank you.
All right, Angelique, you can just.
Good morning once again, everybody. TCF Live. Good to have you with me this morning. Let's go down to Florida. Wade Mercer.
Today, and Corporal, I believe we have one interpreter case we need to take first off of our pretrial docket. That's Andres Mate.
Yes, sir.
Thank you. Mr. Ricardo, can you see and hear us okay?
Yes, Your Honor. Good morning.
Good morning, Mr. Ricardo.
Good morning.
Could you please introduce yourself to Mr. Mate, make sure he can see and hear you?
Señor Mate, soy Jordani Ricardo, intérprete para que se pueda comunicar con el juez. ¿Usted me ve y me escucha? Sí, señor. He can hear me and see me, Your Honor.
Great. Mr. Mate, you're here for, is this arraignment docket or is this pretrial?
Arraignment.
You're here for arraignment docket for 4 charges, sir.
Señor, está aquí para la lectura de los cargos por 4 cargos, señor.
You're accused of 2 counts of indecent exposure.
Tiene 2 cargos de exhibirse de forma indecente.
And you're accused of 2 counts of breach of the peace.
Y tiene 2 cargos de alterar el orden público.
I'm going to appoint the public defender's office to represent you, sir.
Le voy a asignar al abogado de oficio para que lo represente, señor,
and ask that you listen to Mr. McDaniel, your attorney.
y le pido que escuche a su abogado, el señor McDaniel.
Your Honor, I spoke to Mr. Mate in case number 26324MM. He's been here and pleaded no contest to the charge of indecent exposure and disorderly conduct. And the state would dismiss 2 counts, which was 1 indecent exposure and 1 disorderly conduct.
Su señoría, he hablado con el señor Mate en la causa 26324MM. Él se va a declarar no me opongo ante un cargo de exhibirse de forma indecente y un cargo de conducta desordenada. El Estado le va a desestimar 2 cargos, uno de exhibirse de forma indecente y el otro de conducta desordenada.
To understanding, he'll be sentenced to 51 days in jail, credit for 51 days, $370 fine, which will be a civil judgment.
Entendiendo que se le va a condenar a 51 días en la cárcel con crédito por 51 días y que tendrá una multa de $370 como un fallo civil.
Waived his right to a jury trial and call witnesses at that trial.
Ha renunciado a un juicio con un jurado y a llamar a testigos en ese juicio.
I don't think he's here legally or anything, but just in case, he does understand that any plea could be used against him in immigration court.
No creo que esté ilegal aquí o así por el estilo, pero de todas formas, él entiende que cualquier acuerdo en un caso penal le puede afectar en un tribunal de inmigración.
Thank you. And who's covering today?
This one's mine.
Mr. Mitchell's that agree with the state?
It is, Your Honor.
Señor Mitchell, ¿está de acuerdo el Estado? ¿Lo está su señoría?
Mr. Mate, did you hear that agreement, sir?
Señor
Sí,
Mate,
señor.
yes, sir.
What'd you say, Don?
Yes.
Mr. Mate, is that the plea you would like to enter, sir?
Señor Mate, ese es...
Mr. Mate, wait till the interpreter gets through because you asked for an interpreter, so we have one. So wait till he gets through before you answer. Obviously, you speak English pretty well, but wait till the interpreter gets through. The question was, is that the plea you would like to enter?
Señor Mate, espere a que el intérprete termine porque usted pidió un intérprete. Obviamente habla inglés bastante bien, pero espere al intérprete. La pregunta era, ¿es ese el acuerdo que desea aceptar?
Sí, señor.
Yes, sir.
I'm going to accept your plea of no contest to 1 count of indecent exposure and 1 count of breach of the peace.
Voy a aceptar su declaración de no me opongo ante un cargo de exhibirse de forma indecente y un cargo de alterar el orden público,
which are count 1 and 2 of case number 26324MM.
que son los cargos 1 y 2 en la causa 26324MM.
I'm going to judge you guilty of those offenses.
Lo voy a condenar culpable de los delitos.
I'm sentencing you to 51 days in jail with 51 days credit.
Lo voy a condenar a 51 días en la cárcel con crédito por 51 días.
And imposing court costs and fines of $370.
Y le voy a imponer multas y costas por $370.
Those court costs and fines will be reduced to a civil judgment.
Las multas y costas se reducirán a un fallo civil.
Okay, this is confusing.
Sí, señor.
Yes, sir.
Okay, so to clarify, the plea is not to a breach of the peace, it's to disorderly conduct, Mr. McDaniel?
The same charge, same statute.
Yeah, I thought it was the same. I thought it was the same statute.
Y solo para aclarar, señor McDaniel, estamos hablando de conducta desordenada o de alterar la paz. Es el mismo estatuto, o pensé que era el mismo estatuto.
Okay, so we need to, if that's the same statute, we need to do disposition, though. Let's just a second look at the statute.
It is the same statute.
Yeah, so we need to take out all this reference to disorderly conduct because it's the same statute. It's just going to confuse the record. Mr. Mate, so what will happen next, sir, is the jail will do a warrants check on you.
Señor Mate, lo que pasa ahora es que la cárcel va a hacer una verificación a ver si usted tiene alguna orden de arresto.
And as long as you don't have any warrants anywhere, you'll be released this morning.
Y siempre y cuando no tenga ninguna orden de arresto en ningún otro lugar, lo dejan salir esta mañana.
Do you have any questions?
¿Tiene alguna pregunta?
No, señor.
No, sir.
Have a good day.
Que tenga buen día.
Thank you, Mr. Ricardo.
Thank you, Your Honor.
Next case we have, Mr. McDaniel, we do have two first appearances. One of those has friends or family here, so we'll take that case next. That's Jonathan Odom. There's that. Mr. Odom, good morning. Mr. Odom, you're here because you've been accused of one count of aggravated battery and one count of criminal mischief more than $1,000. Mr. Odom, I've read the complaint. There is probable cause for the charges. Mr. Odom, your mother and your stepfather are both in the courtroom. Mr. Odom, listen to the attorneys, and then I'm going to deal with your bail status. We'll start with the state, Mr. Bell.
Yes, Judge. Mr. Odom is currently on PTI in case number 26-CF46 for a different victim, but very similar offense. The state will revoke his conditional release on his PTI. And then we will ask for a reasonable monetary bond in his new case.
Is he on conditional release? Be question one.
He is on a PTI.
But
felony PTI.
I don't know that there is a conditional release. When Ms. Jeffcoat was here, the head of this office, if they wanted to revoke bonds on PTIs, she said, no, we do not want to make that our practice. So there's no conditional release because felony PTIs don't have conditional release. The question is he on bond? And I think the state might have the right to do that. The problem is that I believe his bond was revoked in this case. Here's the sequence. He gets a charge. He's out on bond. He gets arrested again. I revoke his bond, set no bond. The state attorney's office, a week or two later, gives him a PTI on both card changes cases, the one he was on for and the one he got the new charge on. So I don't think I can revoke a bond. I've already revoked it, and not you, but your office gave him a PTI. So I don't think he's on bond. But I'm glad to listen to. If I'm wrong, please let me know, Mr. Bell. I don't think there's anything I can revoke.
Your Honor, I think for purposes of today, the best practice would be we'll address the PTI at a later time if we want to revoke that agreement, and we just give them a reasonable bond with the reasonable condition.
And I think it's appropriate to take into account for bond purposes, Mr. Bell, he's on supervision.
Yes.
And the bond will reflect that accordingly. He is on PTI according to what I read this morning. And it is for a very concerningly similar allegation of trying to hit someone with a vehicle, both that time and this time.
Yes.
Anything else from the state, Mr. Bell?
No, Your Honor.
Mr. McDaniel, anything?
Your Honor, I can always send the state some case law and arguments and statutes that, Ms. Jeffcoat relied on that they can't do that, put them on conditional release like that. And I think they try to not do that because of that. I can send them to them so they'll understand it better. Your Honor, Mr. Odom, he's got severe brain damage. He had an accident. We know that, and we know what's going to happen, and the court's going to set a bond. And he's always complied, Your Honor. I think he has. I don't know why he's held that long. That's all right. But we just asked for a reasonable bond, Your Honor. I think my mother may have something to say. I'm not sure if she does or not, but he's definitely got some severe issues.
Ma'am, do you have anything you want to add? Ma'am, I want to make sure he can hear you. So if you can come up here to the microphone so that your son can hear what you're saying.
Yes, sir, Your Honor. He has been doing so good. He's completed everything. He only likes $40 on his probation, and his probation officer says he was doing really good. And the incident, he was at his dad yesterday trying to change a tire, and Albert Brentsfield jumped on him, and he was getting ready to leave, and that's what happened.
Okay. Are you aware that according to the complaint, part of this incident was captured on video, and the video reflects him backing his vehicle into the vehicle occupied by 2 or 3 people, including the pregnant person? Are you aware of that?
No, sir.
That it's on video, supposedly, according to the complaint.
Yes,
you understand?
Yes,
okay.
sir.
All right. Anything? Any questions for this young lady, Mr. McDaniel?
There you go.
Anything from the state?
There you go.
I mean, he takes medicine. Oh, he takes medicine too, and half the medicine the jail don't give him, and he needs that.
The problem is now, ma'am, this is 2 times he's been accused of trying to run somebody over with a vehicle.
Yes, sir.
I'm afraid he's going to kill somebody.
Yes,
I don't even know why he's driving if he can't control his temper better than that. He may not need to be driving. But what I'm going to do this morning, thank you for coming, ma'am.
Thank you.
I'm going to set your bond at $50,000 on the aggravated battery charge, $10,000 on the criminal mischief charge. Your bond is $60,000 cash or surety. I agree with Mr. McDaniel. I can't revoke your PTI. The state can do what they want with that PTI. They can put it back on the docket or whatever. But had his bond not been revoked previously, Mr. Bell, I think that would be one that you could make that request. I think the state's got the right to do that because it's pending. The problem is his bond was revoked and then the state agreed to let him out without a new bond when they gave him the PTI. And I'm not questioning that decision. I just think it put him in a quandary where you can't now come back and revoke a bond because it's already been revoked. He's not on bond as far as I can tell. So you've got a bond of $60,000 cash or surety. You have a condition not to drive a motor vehicle because now that's 2 instances of individuals that supposedly have been threatened or endangered by your driving. So you can't drive a motor vehicle and you can have no contact with the alleged victim at all. Mr. Odom, do you have any questions?
I do,
I couldn't understand. I'm sorry.
You have a question?
Yeah, I do, Your Honor.
Okay.
Let me try to get his question, Your Honor.
Sure. Just say, wait till he gets through, ma'am, because I want them to hear whatever you want to say, okay?
It's on one, but maybe 2. Here's the other case. Yeah.
It says on PT on both cases. He was only on bond on
25,453 and 2646. Yeah.
If you find out he is still on bond on one case and you want to file a written motion, Mr. Bell, please do that if you think it's appropriate.
I'll check out first premises.
Anything else, Mr. McDaniel?
We don't have any questions, Your Honor. And you know, Mr. Bell, I've got the case, I've got all the stuff at that. I'll send it to you though. But I mean, if y'all put him on PTI, I don't think you can send him back in the docket. But I'll send you the information.
So, Mr. McDaniel, so help for my benefit, Mr. McDaniel, does a conditional release make a difference like we do in misdemeanor court?
I'd rather not talk about it in open court, Your Honor.
Okay. You think it's questionable?
I do.
Okay.
I mean, but
and they don't do one in felony courts. It's clearly no conditional release at all. Judge Hatcher started that process, and I think it's a conditional release until the court says otherwise. It's valid. But this isn't a misdemeanor, so it doesn't matter. Ma'am, you want to say something else?
Yes, sir. And Albert Briscoe had been threatening him, and he told us the other day that he was going to throw a pipe bomb in his vehicle.
Okay.
And then yesterday he pulled a machete on my son, and like I said,
Ma'am, I'm familiar with Mr. Brinsfield's name from the court system, so I don't doubt what you're saying. The problem is, according to the complaint, this behavior was captured on video. The bigger problem is this is twice in about 6 months that he's allegedly tried to run over someone with a motor vehicle. That's the problem we have.
Yes, sir.
It's not being dealt with, so I'm trying to deal with it.
Yes, sir.
Okay? Thank you,
you.
ma'am. Wish you the best, sir. Douglas Harrison's next. Please give him a court date for September 1st at 8:30. Mr. Odom, that is. Mr. Harrison, good morning. Mr. Harrison, you're here because you've been accused of one count. Good morning. One count of trafficking methamphetamine, 14 grams or more. And I believe you're already out on bond in case 26384 MM. Mr. Harrison, please listen to Mr. McDaniel, your attorney for today's purposes, and we'll see where we go from here. Mr. McDaniel.
Your Honor, in 26384 MM, we just asked the court to place that on the jail docket September 9th, move it from the arraignment docket since he's going to be in jail. We just asked for reasonable bond on the trafficking offense.
September 9th. And that's the date he already has set, Mr. McDaniel?
He's set on August 31st right now, but if you're revoking his bond, he's going to be on, he'll be in jail. So we just go ahead and put him on September 9th.
I see what you're saying. September 9th is the jail date. I follow you. Thank you. Mr. Bell, anything from the state?
Your Honor, we would ask to revoke the bond in his misdemeanor case, and the state has also filed a nebia hold on these trafficking charges.
Okay. So, Mr. Harrison, you're entitled to a bond in the trafficking case, but it's complicated. So I'm going to set your bond. Bond I almost always set for trafficking, which is $50,000 cash or surety. However, you can't try to post that bond now for two reasons. Number one, I am revoking your bond in 26384 MM. That's the misdemeanor case you're on bond on. We'll see on the court date that Mr. McDaniel mentioned. The state's filed what's called a NEVI motion. That's what they call it. NEVI is a federal case. It's not a statute. And basically what it does is it tracks Florida's law, Florida statute, which says the judge has the right to inquire about the source of any funds used to post bond. So they're asking basically that I verify, or Judge Garcia verify, the source of any funds used to post bond. The statute does allow the court to do that. So what I'm going to do is determine that you not be allowed to post bond in the felony case unless and until you see Judge Garcia and she has a hearing to determine the source of those funds. So it really doesn't matter right now because you've got the no bond. But when you resolve the no bond case, it certainly may make a difference then. We'll see on that court date or earlier. The reason I say or earlier, Mr. Harrison, is if Mr. McDaniel works something out that you can live with and the state can live with, y'all may see y'all before that court date. That happens with Mr. McDaniel. Sometimes he's very, very good about staying on top of his cases. Mr. Harrison, do you have any questions? Did you have a condition of random year analysis if you ever do post a bond on the trafficking charge? Any questions, Mr. Harrison?
No, sir.
Wish you the best, sir.
Thank you.
I'm sorry?
You need a precise order for this case?
I do. Please. Thank you. All right, Mr. McDaniel, that's it for our first appearance docket. Lex, let me go to one of the other dockets. I've got an arraignment and a pretrial docket. They both have 3 or 4 cases on them. Mr. McDaniel, any preference?
No preference, John.
We'll start with the one I've got on top then. That's the arraignment docket. We've already seen Mr. Mate. Number 2 on the arraignment docket is Kevin McCage. Ms. Kelly, we'll call your case next, ma'am. I didn't see you there. Call your case in just a moment. This is State versus Kevin McCage. Mr. McCage, you're hearing case 26352 MM, accused of 1 count of breach of the peace and 1 count of trespass in occupied structure or conveyance. Mr. McCage, I'm appointing the public defender's office to represent you and asking that you listen to Mr. McDaniel, your attorney.
Your Honor, at this point in time, we're going to ask to put it on the September 9th pretrial, trial date September 22nd. I sent y'all a text message. I don't know if y'all are open to some kind of him going to Chrome. He's talked with the chaplain and they've had interviews with him, and he does have a severe drinking problem which contributed to these crimes and the crime that was in Calhoun County. Obviously, I got to work out something with Calhoun County, but if the court's open to it, then I'll start working on that. If they're not, then I'm not going to work on it, obviously.
Mr. Mitchell.
No objection to that, Your Honor. And I did receive that message that Mr. McDaniel was speaking of, and we'll address that at a later date or before the next pretrial date.
Thank you. So, Mr. McDaniel, I don't know if I am or not. For him to be offered 9 months in jail, that tells me he must have a really bad criminal history. So before I would even consider that, I'd want to know 2 things. I'd want to see the criminal history again. And the second thing I'd want to know is, has he ever been to treatment? How long has it been? Things like that. So those are the factors I would want to know before I would even could tell you if I would agree for him to serve a sentence in drug treatment. But if you and Mr. McDaniel will get that information to me, we can talk about it any day that y'all want, other than this morning, obviously. So, Mr. McCage, we're going to schedule you for that court date. Your attorney just said, sir, 9/9 and 9/22. Give him time to see if you're possibly a candidate to go to inpatient drug or alcohol treatment. But I don't remember your criminal history, but it's got to be pretty bad for me to approve a 9-month sentence. Do you have any questions, Mr. McCage?
Well, yeah, I mean, no, not that it's going to do any good.
All right. Have a good day, sir. Miss Kelly, we'll go ahead and call your case if you're ready. What case is that, ma'am?
Your Honor, I have 2. The first one is going to be Byron Polnitz. He's got 2607 CT and 26208 CT. One's a first-time DWSR, the other's a DWI, and I filed a motion for evaluation yesterday. And we've spoken with Dr. Schuler. She should be able to get to it soon, so we just need them evaluated and a new court date.
Mr. Polnitz, I signed an order this morning electronically in the e-portal to have that evaluation done. So that should happen in the very near future. Mr. Mitchell, anything from the state?
No, Your Honor.
So, Ms. Kelly, tell me your preference as far as scheduling, considering that evaluation is coming.
If we can get maybe a court date in about a month's time, and if we get it sooner, then hopefully we can get it resolved sooner.
September 9th is our next jail case date. Does that work for you, Ms. Kelly?
Yes, Your Honor, that's fine.
Mr. Mitchell?
No objection.
Mr. Polnitz, do you have any questions, sir?
Oh, no.
I couldn't hear you. Did you say no?
Oh, yeah, no question.
All right, we'll see you September 9th, and the doctor will be out there to see you before then, sir. Who else do you have, Mr. Kelly?
The other one I have, Your Honor, is Nicholas Tyndall. And he's
You
got.
cut out on us. You cut out on us, so let me put the style of the case on the record. Estate versus Nicholas Tyndall, 26225 MM, charge of violation of injunction for protection. And Ms. Kelly, where do we stand in Mr. Tyndall's case?
Your Honor, Mr. Tyndall also has a pending felony that's on the pretrial docket for next week. I think that case is driving the boat. Mr. Mitchell had been offering DOC on it, so we're trying to come up with an alternate solution. And so if we can just put him on whatever court date you'd like.
Do you want to do the same court date you just did with Mr. Polnitz, Mr. Mitchell?
We can do that, yeah.
September 9th, does that work for you, Ms. Kelly, since you already got that one, that
Yes,
date?
Your Honor.
Mr. Tyndall, any questions, sir?
Is my court still next week or?
Yeah, it's
a felony case.
Yeah, and I'll be there.
All right. Have a good day, sir. Ms. Kelly, is that all you had this morning?
It is, Your Honor. May be excused.
Absolutely. Thank you, ma'am. We've got a couple of young ladies in the courtroom. Let me see if I can help call their cases or their friends or family cases. Sitting down here, ma'am, what case are you here on? Do you want Mr. Williams to know that you're here? What's your relationship, ma'am? So I can tell him.
I'm his aunt by law, but he know me as his mom.
Bernard Williams, Mr. McDaniel?
Judge, I was not expecting her to be here this morning. I talked to her yesterday, day before yesterday. He's not able to, he's not able to come out. I did not bring him out.
So it's okay. She's raising her hand. You want to call it last?
Yeah, let's do it last. It's kind of complicated and.
Is that the case where the individual has some mental health issues?
Mm-hmm. Correct.
So ma'am, we're going to come back to that case in a few minutes. Okay. We only have like 5 or 6 more before that. In the very back, ma'am, are you here for a different case? I can't hear you.
Trey Singleton.
I can't hear you. Who?
Singleton.
Trey Singleton. And you want him to know that you're here? And what's your relationship so I can tell him? His mom? Trey Singleton's mom is here. So let me go back to the arraignment docket where he's at. And we've got more people coming to the courtroom. Of course, it's still a little bit before 9. Mr. Singleton, your mom is in the courtroom. Mr. Singleton, you're here. You're here in case 25-140 MM. Mr. Singleton, you're charged with 1 count of resisting an officer without violence. I'm appointing the public defender's officer to represent you. Mr. Singleton, listen to Mr. McDaniel, your attorney, please.
Your Honor, I've talked to Mr. Singleton in case number 25-140 MM. We've been plea of no contest, 60 days in the county jail, 30 days jail credit, whatever the remaining, I think it's $370 fine is the remaining amount. State has agreed to dismiss 25-140.
The new case.
The new case, 26370. I wrote the wrong case number down, but they're going to dismiss the battery case. Go ahead and plead to the resistance without violence. Yes,
thank you, Mr. McDaniel.
Wait right to jury trial and call witness. Thank you, Your Honor.
Thank you. Mr. Mitchell, is that the plea agreement?
It is, Your Honor.
And Mr. Singleton, did you hear that agreement?
Yes, sir.
Mr. Singleton, do you have any questions about that agreement?
No, sir.
Sir, is that the plea that you would like to enter?
Yes, sir.
Mr. Singleton, I'm going to accept your plea of no contest to the charge of resisting an officer without violence in case 25-140. The judge you guilty of that offense, sentence you to 60 days in jail, give you credit for 30 days you've already served. Mr. Singleton, the state is dismissing the other case, which is 26-370 as part of this plea agreement. And Mr. Singleton, there's no probation involved in this sentence. You have 30 days left at most. The reason I say at most is you certainly may, and I can't promise you this, I can tell you it's possible under Florida law, you may get some extra gain time and be out in less than 30 days. That depends largely on your behavior and following the jail rules. So you have at most 30 days left and no probation involved in this sentence. Mr. Singleton, do you have any questions?
No, sir.
Ma'am in the back, do you have any questions? I wish you the best, Mr. Singleton.
Yes, sir.
Tell me what case you're here on over here on this side of the courtroom. I'll try to call that case next. Jacob Smith. And you want Mr. Smith to know that you're here? I know that. Do you want him to know that you're here? I'm going to tell him who's here if you want him to know. What's your relationships? I can tell him. His wife. Mr. Smith, your wife and a couple of other individuals are here. You're here on our arraignment docket in case number 26-272 MM. Mr. Smith, I'm going to appoint the public defender's office to represent you and ask that you listen to Mr. McDaniel, your attorney.
Your Honor, before he goes, can I have a moment with Ms. Smith back there?
Sure. Give us just a second, Mr. McDaniel and Mr. Smith.
Sure.
All right, Mr. McDaniel.
All right, Mr. McDaniel.
Thank you. I'm ready.
And so, Mr. Mitchell, the notes on the file, you were waiting to speak with the alleged victim before any offer was made, I believe.
That is true, Your Honor. We had not heard from Ms. Smith. And as you can see, she is here today. I just had a brief conversation with her and went over how she wants to proceed in this case. She does not want to pursue charges in this matter. So based on my discussion with Ms. Smith, the state will announce no information in this case.
All right, so Ms. Smith, Mr. Smith, the state is dismissing the charges against you. Does he have any other holds as far as we're aware of at the jail, Corporal?
Not to our knowledge, but we'll double check you before he leaves.
Thank you. Ma'am, do you have any questions about that? You understand Mr. Mitchell's going to dismiss the charge against Mr. Smith in case he gets him to be dismissed. Was there any type of injunction issued in this case? So Mr. Smith, if the only no contact order was from the court, then that goes away when the case is dismissed. If there's an injunction out there that you've been served with or that she's applied for, that's totally separate. So make sure that you're not violating any law by having any contact. I simply don't know if there's an injunction or not. It doesn't come through me. Okay. Mr.
Yes,
Smith,
sir.
any questions?
No, Your Honor.
Wish you the best, sir.
Yes, sir.
Thank you for coming. Let me finish the arraignment docket. I only have one more on that. Actually, I don't think I have any on the arraignment docket.
No.
We're through with the arraignment docket. So, Mr. McDaniel, who do you want to take next?
Well, we have two persons here with Attorney Mr. Ballack, but I don't see him here. I don't know. I mean, I suspect it was scheduled at 9 o'clock if I recall. So I don't know. Maybe we got Deonte Bellamy and Tapawa.
I think he's appearing by video. I can see him now.
Deonte.
Mr. Ballard, let me take what may be the simplest one, State versus Tapawa Redding. There's only one case in that charge. Mr. Redding, come on up. Mr. Redding, you're here in case 26-353 CT, charge one count of driving under the influence. Your attorney, Mr. Ballack, is appearing remotely. Mr. Redding, listen to Mr. Ballack. We're going to see where we stand in this case, sir.
Yes, sir.
Your Honor, is this the arraignment?
This is the Redding. This is Tapawa Redding. Yes, sir.
Yes, Your Honor. We would plead not guilty at this time.
Mr. Mitchell, anything?
No, Your Honor.
As far as scheduling, I don't know his bond status or anything.
I think his bond has been revoked in a Bay County case, I think, based on this new law charge.
So do you want him on the jail docket or do you want him on the private attorney docket?
I would prefer the jail docket in that situation. I'm sure Mr. Ballack could be available and do what he's doing right now if need be.
Mr. Ballack, we have a jail docket, which are individuals who are in our jail, which that's what today is. We have a private attorney docket, which are for individuals out of custody. The problem is, I don't know if he's going to be in our jail then or not by the court date. I have no problem putting him on either docket, whichever one you prefer. Would you prefer the private attorney docket? That's only if he's out of custody. Or would you prefer the jail docket, which is about a month away?
Let's do the jail. I think, as the ASA alluded to, he's got a hold without in Bay County, and I think that we should be able to get this resolved in some type of global offer. Judge Stevenson gave us his blessing to get whatever we need done. If we can get it done over here in the global, he was fine signing off on that. So I might have to work with Mr. Mitchell just to get this done.
What is the jail date on next jail case? September 9th. At 9 a.m. And Mr. Redding, As Mr. Ballack and Mr. Mitchell know, if they work out something ahead of time, I do first appearances virtually every day, almost every day, every weekday at least. So I may see you before September 9th with your attorney and the state if y'all reach an agreement. Otherwise, we're going to set you for September 9th at 9 a.m. Any questions, Mr. Redding?
No, sir.
All right, sir. I wish you the best.
Thank you.
Thank you. Then we have Deonte Bellamy. Mr. Bellamy, good morning. Mr. Bellamy, you're here in case 26325 MM, charged with one count of stalking or harassment and trespass other than structure or conveyance. And then you're also charged in case 26-20 MM. That is a violation of county probation charge. I think, wait, which one's the VOP?
The VOP is 2620.
2620 is a VOP, and that's a trespass. The docket says trespass after warning. So those are the two cases you have pending. One's a VOP, one's new charges. And we're here for a pretrial. Listen to Mr. Ballack, and then we'll see what Mr. Mitchell's input is, and we'll see where we stand in your cases.
Yes, Your Honor. The victim in the 26325 reached out to our office and provided a sworn affidavit that we disclosed and shared with the state. I believe that brought a resolution to the first count, but we were hoping to reach a global resolution today, Your Honor. I believe that the proposed agreement would be the 60 days for the VOP. I think he has credit for about 50, so that would put him in there for another 10 days. And then there'd be no probation to follow. And that would resolve both his 2620 and 26325.
Is he on for a first degree or second degree misdemeanor?
For the VOP, it's a
Yes.
second degree misdemeanor.
It's a little confusing. It says trespass in a structure or conveyance after warning is what the violation of probation says.
And I filed an information originally for a trespass in a structure or conveyance.
Okay, so I think that's wrong, Mr. Goodson. The VOP affidavit doesn't seem to match the actual charge. So let me go back and look at the information because that's really what counts in the disposition. Well, the disposition, no, Mr. Goodson's office tracked the language in the disposition. So the disposition says trespass in a structure or conveyance after warning. So let's go back and look at the information. The information charging document says trespass in structure or conveyance. So the after warning shouldn't be on there because that's not part of what he's charged with. So it appears you're on probation for a second degree misdemeanor. And Mr. Mitchell, as far as the new case, Mr. Ballack said that resolved count one of the new charge. It's the state dismissing both counts, both the trespass and the resisting. I think the trespass was captured on video, a Zoom doorbell or something. And then the other one was, I don't know the details of the second count, but what's your decision, Mr. Mitchell?
Given our conversations we've had with the victim, we'll dismiss both counts and dismiss that case entirely.
Okay, so given that, what's left then? The state's dismissing the new charges totally. That's their decision to do that. They're the prosecuting agency. They have full authority to do that, Mr. Bellamy. So that leaves a violation of county probation. If you wish to resolve the violation of county probation, Mr. Bellamy, I have no problem sentencing you to the maximum I can, which is 60 days in jail, and giving you credit for what you're entitled to. That's essentially the terms that your attorney has outlined. Mr. Bellamy, you need to understand if you enter that plea and you admit to the violation of probation, then you're waiving your right to an attorney. You're waiving your right to a hearing. You're waiving your right to call and cross-examine witnesses at the hearing. I would sentence you to 60 days and give you credit for the time the jail tells me, and we'll make sure we're all on the same page on that. You would finish that jail sentence or you'd be done. You'd have no more probation in that charge. Is that the agreement, Mr. Ballack?
Yes, John.
Mr. Mitchell?
That is the agreement, Your Honor.
Mr. Bellamy, any questions about that?
No, sir.
Is that the admission you would like to enter, Mr. Bellamy?
Yes, sir.
All right, Mr. Bellamy, we accept your admission that you violated the probation, the terms and conditions of your probation in 26-20 MM, revoke that probation, sentence you to the maximum sentence for that charge, which is 60 days in the Jackson County Jail. I'm also going to order you to pay remaining court costs and fines, if any. $370 court costs and fines you have remaining. There'll be a civil judgment if you don't get those paid. If you get them paid or worked off, that's great. Also, Mr. Bellamy, you're entitled to credit for the time that you served down there. What are you showing on credit for time served, Corporal?
Your Honor, he's got 52 days.
Mr. Ballack, you agree?
Yes, John.
Mr. Mitchell?
We'll stipulate to that, yes.
52 days credit for the time you've already served. Mr. Bellamy, that means you have 8 days left at most. Mr. Bellamy, do you have any questions?
No, sir.
Wish you the best, Mr. Bellamy.
All right, thank you, Your Honor.
Thank you. Thank you, Mr. Ballot.
Thank you, Your Honor. Have a great day. Thank you, Mr. Mitchell.
You too. 4 cases. One is just a scheduling, Mr. McDaniel Hayden Johnson, 26310 MM. I think I saw in a text or email where that one's already been passed to another docket. Is that correct?
Yes.
Correct. We already moved him to the September 16th docket. So,
He's in a rehab facility, right? So let's go back to the one you wanted to call last, and that is State versus Bernard Williams, the young ladies in the courtroom, 26-312 MM. So, Mr. McDaniel, anything that you want her to be aware of? I know that you said he wasn't in the state of mind to come to court this morning, but what did you want to tell her?
I guess I was not expecting her to be here today. Have you secured that location for him? I forgot. Let me get to your information.
Ma'am, I want him to be able to hear you. Do you mind coming on up, please? She has some paperwork with her. Let's see what am I looking at? Okay.
This is Alice Curry. Is Alice I'm speaking to here? Seeing?
No.
Let me straighten something before the court. I've had Bernard since he was 1 day old. I'm Regina Webb. I'm his aunt by law, but he called me mommy. You spoke to Alice Curry, which is his biological mother, and she's trying to get him transferred to Fort Myers, where he could be put in a living facility. I don't know if Bernard is going to agree on that, but I was not the one you were speaking to.
Okay. Have y'all found a place for him to live at then, or or at your house? Or where are you from, ma'am?
I'm from Mariana.
Yeah, that ain't gonna work out because he keeps doing stuff. I mean, is there someplace else that he can go?
No. Hold on. We're trying to get him put down south, but you're saying it won't work out with me. That was not the problem. The problem is, since we've been here, because we just moved here recently, Bernard, his medications has not been stable because they keep putting him on different meds. I'm having problems with people's understanding what works for Bernard. I had to rush Bernard to the emergency room June. I think it was the 9th.
Let me ask you a question, ma'am. Ma'am, you need to have this conversation with his attorney in private, not on Zoom about his mental health issues and everything. Have you spoken to his attorney, Mr. McDaniel?
No.
Okay, you may want to do that. You may want to speak to his attorney at some point after today. I would encourage you to do that. We'll give you his phone number when we get through the court in just a second. So let me see what they want to do, and I'm going to see if you have any input about that. Mr. McDaniel, as far as scheduling, what do you want to do with this case today? Is to give you time to talk to this young lady about.
I'm gonna just put him on the September 9th court docket, Your Honor. And I spoke to Miss Curry, so our office is right across the street. Miss Sissy Tools over there. If you would go by, see her, give her your phone number and information. She'll send it to me. I think right now I'm just trying to look for some place for him to go that someone can watch him, because I don't think he can be left alone. And I don't know who's watching him in Mariana, but
he can't be left alone. That's why she was trying to find him a place to go to, like an assistant living or something, because he needs 24 hours care.
Okay, September 9th, Mr. Mitchell.
No objection.
Ma'am, do you have any questions?
No, I'll talk to him.
They're right behind the courthouse on Jackson Street, the public defender's office. His suggestion is to go by there and ask for Sissy.
Sissy?
Yep, and we'll give you, it says Office of Public Defender right on the door. It's literally right outside across the street. Okay?
Okay.
Thank you, ma'am.
All right.
So we'll schedule it for September 9th. Mr. McDaniel is really good about bringing cases up early. So if y'all get a placement for him a week from now, he's going to go ahead and bring him up early, and they'll let you know if that happens.
Okay.
Thank you, ma'am. Thank you for coming. Mr. McDaniel, that's it. As far as first appearance docket that I'm aware of, and the pretrial and arraignment dockets we had. Mr. McDaniel, anything else from the public defender's office?
Nothing else, Your Honor.
Thank you. Mr. Mitchell from the state?
Nothing from the state, Your Honor.
And Corporal, anything else from the jail today?
No, Your Honor.
No.
Alrighty, fairly busy morning for Wade Mercer. Good morning, everybody. Hour 2 now of TCF Live. Good to have you here with me today. A couple things. First, earlier, Barbara left a $5 super chat. Said, good morning, everybody. Happy hump day. Don't forget second session. Indeed, 2:30 p.m. Eastern, 11:30 a.m. Pacific. Our newest show right here on TCF. Do join us for that. It is more court, but a little bit different feel than what we do in the mornings. So encourage you to join for that. And thank you again, Barbara. Also, during this this Wade Mercer session, I believe it was Julie who asked what a PTI was. And Michael and I let her know. But this is a great use case and a good reason why TCF Court Watch exists. TCFCourtWatch.com. If you go over there, there's a glossary. And we have now 350 different legal terms. And it grows every day, and it's actually pulled from the transcripts of this show. So every day we scrub the transcript looking for, Specs did, sorry, one of you asked. But anyways, every day we pull legal terms out of the dockets, out of the transcripts, and we add them into the glossary, so it is very pertinent to what we see here. So if you have questions about what something means, you can go right there and look it up, and odds are it's in there. So do check that out, tcfcourtwatch.com. Okie dokie, let's go to Texas. Judge West.
Are you David Boyd?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Let me get it pulled up the right way real quick.
Judge, what we're doing is pleading him to the, it's the same offense, deadly conduct, just under 22.05A, which makes it a Class A misdemeanor.
05. All right. Mr. Boyd, in cause number 25 DCCR 0720, the state has elected to proceed on the lesser included offense of a Class A misdemeanor of deadly conduct, and that's from March 20th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with?
Yes.
I have here on the tablets some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Jeffries? Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, Your Honor.
And it looks like the agreement that you've reached is for a 1-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, Your Honor.
And are you a U.S. citizen?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Boyd is not competent?
No, Your Honor.
All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney, defer all proceedings, and place you on probation for 1 year. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do that, this is a great opportunity because you don't have conviction on your record. And at the end of the probation period, if you successfully complete it, the case will actually be dismissed. You'll never have the conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and sent to the county jail for up to 1 year. Do you understand?
Yes, ma'am.
I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. If you'll just have a seat here in the courtroom, probation's sitting at that desk right over there. She's going to call you up to her desk to go over all of your paperwork when she's ready. All right, good luck to you, sir. Thank y'all for working this out.
Thank you, Judge. Thank you. Yes, sir.
It's going to be hard to get through a bunch of words.
Now
It's going to be hard.
Now I get to go and use a teacher.
Have fun. Harold Denton. Yeah, how are you? Yes. Have you ever been? Good morning.
Good morning.
Good morning.
Sure, how many count you want him to plead to on this one, Judge? There's an agreement for 7 years TDC.
Okay, I'll take a look at the,
I'll wait any of them that you don't deem necessary.
Sir, are you Harold Denton?
Yes, ma'am. How are you?
Good, thank you. And, Mr. Lewis, will your client waive the formal reading of the motion?
You do it, Judge.
Mr. Denton, in cause number 21-37744, I have a motion to revoke the community supervision. Shows that you were placed on probation October 20th of 2021 for the offense of assault on a peace officer, a second-degree felony, and that was a 10-year prison sentence that was probated for 10 years. Is that correct? This motion alleges that you violated your probation. It alleges in count 1 that you failed to report to the probation office as ordered September 26th, October 17th, November 13th, and December 1st of 2025. And is that true or not true?
True, Your Honor.
Count 2 alleges that you failed to immediately report your home address and phone number also to the probation office as required. Is that true or not true?
It's true, Your Honor.
Count 4 alleges, I'm going to dismiss 3. Count 4 alleges that you failed to be placed on the mental health initiative caseload as ordered due to the fact that you absconded and you were unavailable for placement. Is that true or not true?
Yes, ma'am. That's true. I had
Count,
difficulties.
I'm sorry.
I had some difficulties. They stole my medications from my backpack at the bus stop, and I just.
Okay. Count 5 alleges that you failed to successfully complete the BIP program. Is that true or not true?
The what program?
BIP, the battering intervention and.
This is true. Yes.
Okay. I think with the agreement, if y'all are okay, that's fine.
9 was the failure to complete.
There we go. 9, count 9 alleges that you failed to enter and successfully complete the Safe P outpatient aftercare. Is that true or not true?
Aftercare is from I successfully completed this.
Right. This is just the aftercare. You got to do the whole thing.
Yes, ma'am.
All right. Did you enter your pleas of true to counts 1, 2, 4, 5, and 9 freely and voluntarily?
True. Right.
And did you plead true to those counts that you pled true to freely and voluntarily?
Yes.
Okay. And I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Lewis?
Yes.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Denton is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, 4, 5, and 9 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time, revoke the probation. Reassess your punishment in accordance with your agreement to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk with Mr. Lewis. All right, good luck to you, sir. You can go back with the bailiff.
He was on strike probation. He definitely beat that.
Well, his was in 21, and I think we started, I think it was 22 or 3 when I started reading it. So in my mind, if it was 22 or before, because I can't remember, I just do it again.
Yeah.
I can't remember the exact day. And, and I need to say so many more words today.
That's what I was looking at. Sounded like we only had you for a little bit this morning.
Yeah, luckily it's not a big day. Let's see.
Alrighty, friends. Well, she's between contestants. Let's go across the hallway. Say good morning to Judge Stevens.
For 6 months just to make sure she's still paying, and she's still paying. So
is she still paying?
She
good?
is.
Well.
Well, the only thing was
Oh.
February through May, she didn't make any payments.
she has a financial trouble.
Who does?
Oh, I know, but it was.
What's the balance on this?
The remaining balance is $69,713.
She's paid.
She's paid $55,287.
So where are we?
Just still making payments, trying to catch up. She's on a non-reporting probation. She's this is being held over just with the verification. It's a full case. So it's just a matter of.
And she's paying at a rate of $500 a month.
Yeah. So she's.
So that's 6,000
right.
Yes, sir.
a year. And how much is left?
$69,713.
That's still 12 years to go.
And she pays when she can pay more. She's been paying more, and I know for a while there she had kids in high school and at home, but now she's an empty nester, I guess now. Or no, well, very college. I guess that's just bad. But what I'm getting at is getting her expenses or should be getting less than they were in the past, and which means she can make more payments as time goes on.
Okay. This was something that occurred 20 years ago.
Yes.
And
she's on probation for 10 and has in and out.
I know, but I don't feel sorry. I don't have any, I have sympathy for Mr. Humphrey, who was was a very benevolent man. When we worked hard for what he made, he was very successful for what he did. But this has been 20 years, and the thing that is on restitution is we don't order what in some states they do, what ought to be done, and that is the restitution plus interest, because you're just playing dollar for dollar. This is like when you took the money, it's like a no interest loan that you're paying back on your term. All of that's not right. I mean, you shouldn't have done it in the first place. You should have paid it back as soon as possible. And it's somebody's out 6 figures and all of this. What was the total loss? 125,000. And still, we got 10 years to go at this rate. Still, we should live so long. Yeah, but I'm railing on, but it's just not fair. And the problem is the door is open, and this is the way it is. I just wish we had interest added on to it, which would make it more fair for the victim. But they're getting on your terms. When you decide you can pay dollar for dollar, and it's already taken 20 years. And you're still only halfway through. I just don't see fairness, which is what we do here. People make mistakes, then you fix them as quick as you can. It shouldn't take 40 years to fix them at no interest for the loss, dollar for dollar. With the way costs from what money is worth 20 years ago, it's reduced significantly. So you're ordered to pay how much a month? How much?
I should write down it's $500, Ron.
Okay. And your income has not changed since the last time we met?
I've got one in college and I don't have the other two obviously living with me. But income has gone up a little bit, but yes, I can start paying a little more. This past earlier this year, I had my daughter's car. I had to have someone pay over. Well, I expected.
I paid my way through college. Every guy. All my education was paid by me. Undergraduate, graduate, and law school. My parents never paid anything. But the person who's in school that you're paying for, they don't have a job or something?
She works part-time at Market Basket, which pretty much just pays for her gas. They don't give them much hours.
Right. Any other, have we looked at all other options available to try to increase the payments? And is this where we are? Are we at a standpoint?
I think at one point you even got her financial records in the past and looked at that and reviewed it. And that's,
Well, I know.
yeah,
I
no, so,
know.
so this is what she can pay right
I know
now.
it was just frustrating, but
But it is what it
Yeah,
is. But she can only pay. Hey.
I mean, that's a lot of money that is stolen. And then now we're shrugging and kind of shuffling around about, well, I don't like it. It's not right. It's not fair. I'm not sure what I can do about it. How often are we reviewing it? Every 3 or 4 months?
It's been every 6 months.
6 months.
Get a resetting.
Gigi, thank you for gifting 5 memberships. I very much appreciate that. And good morning. If I missed you in the chat earlier, I should have said good morning and I didn't. So good morning and thank you for the memberships.
Probation, Mr. Johnson was doing everything she's supposed to be doing, things on the tablet. She is still on probation. She comes.
Wait. Yeah. They dismissed the motion?
Yes, Your Honor.
She pleaded true to theft while on probation for a crime.
I'll confer with the probation department. They're in agreement with the dismissal.
And then just let her continue on probation.
What happened to the underlying theft case?
I'm not exactly sure.
I don't know, sir.
Well, I mean, shouldn't we know? I mean, she committed a crime while on probation. I never just dropped that. Why are we just dropping it? I know there's something I don't know, but she pleaded true to it and pleading true to drugs, drug screen.
I think probation has something to offer on it, Judge.
Why are we just letting her commit crimes? That's 2 crimes, theft and drugs. And then we're rewarding her?
I think there was an amendment, right?
There was an amendment, I think in October before I came on, to send her to ISF, the 0 tolerance. And she finished the ISF and she's been testing negative on her drug screens. And since then she's become employed. And her last drug screening was August the 5th.
Okay. So we're just going to dismiss the motion. She's still on probation.
Yes,
sure. She's on probation.
What about the completed defensive driving program?
That was, we didn't put that in there because the orders said a theft class, but it was for evading. So we had to file another order to dismiss the theft class for the evading and then add the defensive driving for the evading.
So where are we on that?
So that one, we're getting to where she's going to take it.
Well, it's about a year since we ordered it, right?
Yes, sir. It was.
Are you squeezing this into your busy schedule?
Yes,
I don't mean to be a smart aleck, but you committed a crime. We gave you a break, and then there's some more crimes being committed and foul ups, and then we're cutting you some slack. Why is that? I don't know. That doesn't seem fair to other people on probation. I got 5,000 people on probation. They're going to be treated fair. They're going to say, well, I'd like the breaks that Evan Johnson is getting, please. And how do I say no? I mean, what's fair is fair for one. Well, you open the door for everybody, right?
Completely understood, Judge. The thinking was there has been a sanction. There has been a price paid for this opinion. And after consulting with probation, the states have the opinion to leave her on probation. If she screws up again, this will also could be part of the next motion to revoke.
Oh, and how could that scare anybody when we handled this by just dropping everything? What are we really doing here? If we're not acting on what we say, we file a motion and then it's dismissed, and then our plan is, well, we'll just file another motion next time.
Well, the probation sanctioned her, Judge.
Yeah, but it's, you know, at the end of the day, it's my choice.
Yes, sir.
It's on this court's probation, and you don't commit crimes, and it's two crimes after you were placed on probation. On this theft of property, what was that? It's like, it's less than $750, but what was, did she pay that back?
I don't know, sir.
Well, she pleaded true to, did you pay that money back or whatever it was on that? Hold on, everybody. She pleaded true. What did on November 25 to that? Well, there had to be a sanction, right? And what was the sanction then?
She did get, Your Honor, for that 46 days in county jail.
Okay.
I'm looking that up.
Let's see, was there a loss involved on that?
I don't see restitution ordered on the theft case.
Let's see, what is it?
Did you have a 15 record just to check?
Let's see, August 24th.
That's
August 24th. Let's see. Evan Johnson entered a vehicle, a Ford Fusion, and fled from the parking lot. He stopped at a signal line. Traffic stop was conducted. Due to a strong odor of marijuana emitting from the cab, a probable cause search was conducted. While conducting the search, stolen items matching the description from target loss prevention manager were located in the back seat of the vehicle. On my watch.
So the items were recovered, Your Honor. I think it's what it was. Because I'm looking at
Not because of her.
Well, but they were recovered.
And Judge, we're
Both
happy.
individuals were observed. There are two people, Evan and another person, were observed concealing merchandise in their clothes, walked past all points, and the total value of the items were found to be right at $180. And it looks like the items were all recovered and returned. So there's not a loss to the store that got it back, but
We're happy to proceed to a hearing, Judge, if that's what the court.
Your Honor, I mean, back in November when she pled true to this, you sent us your ISF that like, I'm gonna agree with the state. And this is 2 days in a row, I agree with Mr. Coleman, which is getting scary, but we are agreeing here that she's been sanctioned. You sanctioned her by sending her ISF. She did that. And now she's on ISF and the state doesn't want to keep this open any longer in the sense that she's on the right path now. And if she screws up again, then.
But you forgot, I'm the one that ordered the motion.
Sure.
And at the end of the day, and there are still two items that she didn't plead to: failing to perform community service hours and failing to enter and successfully complete defensive driving. Sorry, those haven't been dealt with. How are they going to be dealt with?
Well, we're happy to proceed with the hearing if that's the course.
I just wanted to do these things.
Yeah.
Successfully.
And since she hasn't pled true to him,
what are we going to
she
do
doesn't
on
do
the
that.
defensive? She was ordered to do that. Where is that on that? Have we done that yet?
I'm in the process of doing it now.
Sir, the ma'am?
I'm in the process of doing it now.
What, you're in the what?
Process of doing it now.
Well, so what is it, the process? Where are you on? Well, tell me what the process.
Again,
How long have you had the paperwork?
I just got the paper since I went to visit my probation officer.
When
Before.
did she get paperwork for this?
Whenever she came in July.
In July?
Yes.
Okay, last month.
Because the original order had theft class on an evading charge. And we had to send another order to change it to defensive driving. And that happened in March.
Okay. All right. So she still needs to do that.
Yes, sir.
When is that going to be done?
I'll be done this night.
Yeah. 30
It can be
days.
done as much.
Okay, that's ordered. You gotta do that. You gotta begin that within 30 days. And you don't understand, you're getting benefited from it. You take that and your insurance will drop. The insurance costs will drop. I mean, it's in your best interest anyway. Get that accomplished as soon as possible, okay? And what else?
Well, I think the state's requesting to dismiss the motion to revoke, and then put her back on just regular leave her on probation.
We're gonna dismiss it after she finishes the defensive drive. We'll just hold it and just dismiss it once she completes it successfully, okay?
That works.
All right, Chief.
Thanks,
So
Judge.
hard you're doing the right thing.
Yes, sir.
Thanks. All right, Michael Johnson.
Mr. Johnson.
And how are we doing on with probation?
He's doing well. The only thing he hasn't done yet is the more recognition therapy because we are waiting to get a later date for people who work past 5 o'clock so they can attend the evening classes.
Where are you working?
Eagleo distribution.
I'm sorry, I can't.
Igleo.
Yeah, what do you do there?
Bill Sanders,
How much are you making an hour?
like 15.
Sir, about 15?
15, right?
Oh, yeah, that's over 30,000. That's cool. Good start. Good start. So from probation,
Yeah, he's doing really well. He's making payments. So far he's made.
fix this. You can do it.
Yeah.
I believe you're far better than what happened here. So do it. Yeah.
Yes.
Yeah. Make your family proud and you and move on successfully from this. You were placed on probation a couple of years ago. So what else? Anything we need to deal with or tinker with? No?
I'd like to submit a dismissal on the motion to revoke probation, Judge.
Okay. It'll be dismissed.
Thank you, Judge.
You ever wrote by doing well?
Good to.
Thanks, Mike. Rachel Langham.
You did. Alrighty, well, Judge muted himself, so we'll look at coming back at some point. But let's head a little bit east. We'll go to Louisiana, check in with the board.
Today is August 12th, 2026. The time is 8:58 a.m. My name is Cheryl Renatza. I'm serving as chairman of today's parole panel. My colleagues this morning, seated to my left is Mr. Danny Byron, and to my right is Mr. Pete Freeman. We are at DOC headquarters in Baton Rouge. I'm going to ask the staff here to please introduce themselves for the record.
Francis Abbott.
And our first remote location this morning is at the Calcasieu Correctional Center, and I see there's a staff member present. Sir, would you introduce yourself for the record? You're still on mute, I believe.
Can you hear me now?
We can. So what's your
Deputy Marquez.
Thank you, Deputy Marquez, for accommodating us today. And before us is Mr. Johnston.
Yes, ma'am.
Mr. Johnston, would you introduce yourself? Tell us your name and DOC number, sir.
Kevin Johnston, 101454.
Yes, sir. That's what I have. And do you have any paperwork there with you? Is that a parole revocation questionnaire?
Yes, ma'am.
Is that your signature at the bottom of that page?
Yes, ma'am.
Okay, good. That, the information contained in that document, Mr. Johnston, tells us that you're not eligible for us to appoint you a lawyer today. So are you ready to proceed, with the revocation proceeding, or do you want to hire a lawyer?
Well, I'm indigent.
Sir?
I'm indigent. I said I'm indigent.
Well, I understand, but based on the Supreme Court guidelines and your answers to those questions, even though you're indigent, because you're an inmate, you're not eligible for us to appoint you a lawyer. So you ready to go? You ready to proceed?
I reckon.
Okay, so your case has been assigned to me. I'm going to read the allegations against you, and you'll enter a plea of guilty or not guilty, and then we'll talk about it. Okay?
Yes, ma'am.
You're violating condition number 2, and it states you have not reported to Lake Charles Probation and Parole since July 2025. How do you violating condition number 2? How do you plead? Guilty or not?
Not guilty.
Okay, and I'll take your statement in just a second. Condition number 4, it says on or about October 21st, 2025, you engaged in criminal activity as evidenced by your arrest by Calcasieu Sheriff's Office for unauthorized entry of a place of business, possession of synthetic marijuana, first offense, possession of drug paraphernalia, first offense, and those are currently set for a jury trial. How do you plead to violating condition number 4?
Not guilty.
Okay. And then last, it has to do with your fees. That's condition number 10. It says you owe $1,638 in late supervision. How do you plead to that violation?
Guilty.
Okay. So tell us about why you haven't. Well, you pled not guilty to not reporting to the probation officer since July of 2025. Explain that to us.
I have went to the office and reported, and my parole officer was not there. But I signed in. My name is on the sign-in sheets. The lady at the desk gave me a thing to fill out. I filled it out and gave it to the lady, and she came back and said my parole officer was not in. I did that 3 times, three different occasions. And I don't
have that document. Let me see. It says you failed to report between the dates of July 9th, 2025 and October 22nd. Do you have that document?
That they should have it on the sign-in sheets.
Well, that's not up to me to go find it, but during your preliminary hearing, you said you couldn't recall the last date you reported. So we're going to move on to number 4, which has to do with the criminal activity. You pled not guilty to that as well.
Yes, ma'am. So I'm homeless, living in the woods. Okay, I don't have nowhere to live. Now it's raining, pouring down rain at night, and I met some people that was at the Exxon, and they said I was soaking wet, cold and soaking wet. And they asked me where was I sleeping. I told them in the woods, and they said, well, they have a spot but back behind the old motel room, and I could come up in there with them. Said that homeless people stayed up in there. So it wasn't nothing broke into or nothing. Just walked in through a big place, a big hole. It was a big hole right there, and we just walked in. So I didn't break in nothing.
At the Scottish Inn in Lake Charles is what you're talking about?
Yes, ma'am. In the back, there wasn't no business back there. It was just like storage. It was just like storage unit, storage place. Mattresses and stuff was in there, wasn't being used.
There was over $1,000 in damage to the room.
Well, I went in there one night.
Breaking open the window and left a large amount of trash all over the room, trashed the room.
No, ma'am. No, ma'am. All that was already done. I was in there for maybe 5 hours. It's homeless people have been staying in there for months and months and months. I was in there for 5 hours. That was already done.
So it says you did admit in your preliminary hearing, and I guess you just admitted to us, you did admit to having unauthorized access. What about the drug paraphernalia?
No, ma'am. I didn't have any drug paraphernalia. I didn't have anything.
All right. Let's see. I'm gonna ask my colleagues if they have any other questions.
So you got out and you didn't, it looks like you didn't report at all. You got out of a program and they couldn't find you. They got a warrant. They found you when you got some misdemeanor activity back in May of 25.
Yes, sir.
And when you got out of jail then, I see they gave you a sanction. Did you report to the office after that?
Yes, sir, I did. Yes, sir, I did. I went to the office and my parole officer was never there. I went several times and my name is on the side.
Went to the office on 7/9/25. It shows an office visit. Okay. I don't have any further questions. He is on this.
All right. What concerns me, Mr. Johnston, is you have an extensive history of supervision. You know that.
Well,
since your original sentence conviction, 1983, and you've absconded a couple of times.
Well, I didn't have no word.
You were, when you were released, let's see, that was in 2024, you were released from a work release program, were you not?
Yes, ma'am.
And so
yes, ma'am. Because I don't have no, I'm not from here. All my family and everything has passed away. I've been locked up for almost 38 years.
Where is your family?
My family's up north.
Where are you from?
I'm from Epps, Louisiana. West Carroll Parish. And all my people's done died and gone. I've been locked up almost 40 years.
So you don't have anybody in Epps anymore?
No, ma'am. And I don't know nobody down here. I've never been here before. I don't have nobody. I'm just like by myself.
All right. Well, let me call for executive session.
I second. Approve.
No, without objection. Mr. Johnston, we're going to go into executive session for a few minutes to discuss confidential matters. Stand by. We'll be right back.
Yes, ma'am.
Well, alrighty then. Will they go into executive session? We will go to Judge West and we'll check back in once they are back from their executive session.
Good morning. Are you Perry Hurd Jr.? I'm sorry.
Right.
Okay. And this is cause number 26 VCCR 0052. Mr. Hurd is charged with harassment of a public servant. I want to take judicial notice of the court's file. I received a report from Dr. Capon with regard to competency, and that report is dated June 23rd of 2026. The finding in the report is that Mr. Hurd is competent to stand trial. Is there any other evidence with regard to competency?
No, Judge, not from the state.
Right, that at this time, based on that report, I am going to find that Mr. Hurd is competent to stand trial. And what is the announcement?
Judge, I have received a new offer this morning since visiting with Mr. Hurd in regards to his offense, Judge, and I think it's something that could possibly resolve this issue. If I can just get a short reset in so I can explain that and go over with
Sure.
Mr. Hurd.
You want a week or two?
About 2 weeks.
Okay, we'll reset the case 2 weeks, Mr. Hurd. Mr. Lewis will be out there to go out and visit with you about all your options, and we'll get an announcement at the next court date.
This is the court date for today, right?
I'm sorry?
So this is my court date.
Today's your court date, but I'm gonna move it for 2 weeks so that Mr. Lewis can spend some more time with you going over everything, okay?
All right, so I've been in there long enough to let's see if I need time served or how.
Talk to Mr. Lewis about all your options and he'll let you know what they are, okay? All
Okay.
right, he'll be out there to go over all of it and make sure.
Looking good for him.
He'll be out there to go over all that, okay? You can go back with the bailiff.
I'm gonna talk to y'all whenever.
All right.
No problem.
Denisha McMillan.
Yes.
Morning, ma'am. Are you Denisha McMillan?
Yes, ma'am.
And this is cause number 26, DCCR 0647. And I'm going to take judicial notice of the court's file in Ms. McMillan's case. Ms. McMillan was evaluated for competency to stand trial by Dr. Capon. I received that report dated June 23rd of 2026. The finding in the report is that Ms. McMillan is currently competent to stand trial. Is there any other evidence with regard to competency?
No, Judge, not from the state.
Then at this time, based on that report, I am going to find Ms. McMillan competent to stand trial. Mr. Lewis, will she waive the formal reading of the indictment?
She does.
Ms. McMillan, you're charged with a third-degree felony offense of injury to an elderly individual from March 16th, 2026. And how do you plead to that charge?
I plead guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And did you plead guilty because you actually did what they charged you with?
No, ma'am, I'm just ready to do my time.
Well, it doesn't work like that. If you didn't do this, then you get a trial. So here's the thing, before you go any further, when you stood over in front of the clerk a minute ago, you raised your right hand and you said you promised to tell the truth, the whole truth, right?
Yes, ma'am.
So if you're guilty, you're guilty. If you're not guilty, then we'll get your case set for trial, but I'm not going to allow you to plead guilty with something you didn't do.
Yes, ma'am.
Okay, so if you want to talk to Mr. Lewis for a minute again, that's fine. If you're going to take responsibility, then I'll ask the same questions again, but that's going to be up to you.
Yes, ma'am.
What do you want to do?
I mean, I don't have anything to say with it. I know I never touched him.
Okay, so then I'm going to delete this paperwork, and what we'll do, Ms. McMillan, is I'm going to set your case for trial.
Yes.
When I set your case for trial, Mr. Lewis is appointed to represent you at this point. He handles a lot of cases for me here as a appointed attorney. With your permission, I can release him and I can appoint another attorney who could get ready for trial a little quicker. Is that okay with you?
Yes, ma'am.
All right, then, Mr. Lewis, you're released. Ms. McMillan, we will get you an attorney appointed today. They'll be out to see you very soon to begin preparation for trial.
Yes,
All
ma'am.
right, you go back with the bailiff.
Yes.
And Mr. Smith, if you'll make a notation, make sure, obviously, that's.
So, fun fact, there was a time where I actually, for a brief period, wrote ads for Groupon, but I don't remember Dr. Groupon, so that must have come along after I did that. All right, hour 3 of TCF Live. Let's do this because Todd asked. Let's spend 1 minute or so with the Bears, and then we will go back to Louisiana to finish up that hearing. Yes, Lone Wolf. Da bears. All right. Nature scene done been had now. Let's go back to Louisiana, finish that up.
All right, Mr. Johnston, we're back in regular session. We've had quite some discussions about you, and we see though that you have a trial date coming up in October. It says October 5th, you have a trial date. And it would be our preference, based on everything you've told us today, to continue this matter, the revocation proceeding, until after that is resolved in court. You understand?
Yes, ma'am.
So my vote today is to continue the revocation hearing until after your October 5th trial date. Mr. Byron?
I concur. Continue to the outcome of the pending charge.
Mr.
And I also concur.
All right, we will see you again, Mr. Johnston. Good luck to you, sir.
Yes, ma'am. Thank you.
And so that is concluded. Back to Texas, Judge Stevens.
Rare for me. So, but I tell you, I almost forgot because it had been so long that, and then, so what is this? And there it is in the mail. I said, my God, it really did happen. What
August.
Anyway,
Let's say July.
okay, 26 CR 603. It's Rachel Langham, who's you're charged with this third-degree felony. We're here on an announcement. Where are we?
She has attempted to and working on hiring Mr. Kimler. She's been trying to get with him. She has an appointment Friday to sit down with him to sign the contract and to retain him. I'm a court-appointed attorney. I'm happy to stay on until that happens, but I would just ask for a little time for her to take care of that, a couple of weeks for Mr. Kimler to get on and then let him do what he needs to do with it.
Okay, it was indicted in April. Oh, what a small world, April 15th. So we know that's been 4 months.
We know how long that is.
Since we tabulated it up.
Yeah. So it's not an old case. It's,
well, but I'm sure that
I would hate to start doing.
I'm sure that victim doesn't find it amusing. That's why, and that we're talking about an elderly person is a victim here. And what is it? The
credit card.
Is it $320?
Of the exam.
That is?
I have to discover.
Yes, sir.
Yeah, it should work out.
What is it with him getting all muty today? I don't like that. Angers me. All right. Back to Judge West. We'll go across the hall until he gets his stuff sorted out.
Kadisha Scott.
Yes, ma'am.
And this is 26 DCCR 0797. Ms. Scott is charged with the first-degree felony offense of aggravated robbery from July 3rd of 2025. And what is the announcement?
Judge, in this situation, we have the complaining witness who's evidently been trying to get in touch with the state in regards to this issue. And actually, I talked to the complainant myself a few times where they've called me saying they've called trying to get in touch with the office. I've given them their number up there so he can get that taken care of. That's the main weight that we have on our end.
Sure.
And Judge, I mean, in the meantime of that, of course, I would like to possibly either, I know we may not be able to take care of it this morning, but at least get a bond hearing set from Ms. Scott until we can get that worked out.
Let's do this. I mean, is there any reason you can't try to get that worked out this week to get in touch with him?
This is a case I inherited from Mr. Coleman.
Okay.
The number that Mr. Lewis has for him is the number that we have in the file. We did send him a letter. Tommy sent a different letter than we normally send, and it was returned. So I don't know about the address, but the phone number apparently is good. I didn't have a message that he had called, but I will reach out to him.
Okay. Let's do this. I'm going to reset it 2 weeks, and that'll give Mr. Smith time to kind of get caught up, make that phone call, get in touch with them. If by that time, between now and then, if you want to go ahead and file a motion for bond reduction, that way everybody's on notice and we could have that hearing on that date if something else doesn't get taken care of.
Good.
Okay. All right. See you back in 2 weeks. Joshua Smith.
Can you speak to somebody?
Yeah, the whole time for us.
She's muted. All right. New contestant in front of Judge Stevenson. Somebody tell me what it is with all the defendants wearing safety yellow. It's a thing now.
Oh, there's the motion. Hello. Who's it? With the money thing, that's why it's been sitting around.
Yes, sir.
Who's this?
Mr. Laverne. Derek Laverne.
Judge, his probation has expired for a long time and it's not restitution, it's fees and stuff. So I'll file a motion to dismiss.
Oh, okay. Well, you object to that?
Nope.
All right.
Okay with that.
Wise move.
No.
What are you on defer? Is he on defer?
Yes, sir.
Go and sin no more.
Yes, yes, ma'am.
I was tired of dealing with it anyway.
Well, you did it.
You do what you're supposed to do.
You fixed, you made a mistake. Welcome. The whole planet makes the mistake. And we all do numerous times. It's how you fix it. That's the test. You did well. Thank you. Good work.
Also, I'll see you.
Luis Valencia. Luis Valencia in cause number 26 CR 669. There is no answer. I asked the bailiff to call into the hall.
Huh?
For Luis Valencia. Luis Valencia in the hall.
I remember.
Okay, so you're not.
Yeah, he's not gonna be
Anybody at all?
here. Okay.
Not here.
Yeah, he got it.
Anybody call out the hall at all?
I think the government gave him a ride back home.
Did you yell louder? He's across the border.
Oh,
He got deported. Yeah.
Yeah, so
He did a cash bond, so there's a spike.
so he's.
Oh, cash bond? Okay, well, we can revoke the cash bond and then I'll dismiss. What do you mean no?
You were supposed to be looking at the person who wrote the.
Oh, the lady,
All right, there is no answer. We called the name here in the courtroom and in the hall. Defendant has failed to appear. He's charged with a third-degree felony of evading arrest.
yeah, there's no priors and he's been deported.
It says, hello, my name is Kimberly Lazaro. I am the person who paid Luis Valencia's cash bond. As you may know, he got deported and we never got our cash back.
Okay.
Okay.
All right. I'll dismiss it, Judge. We just get rid of it. It's that he doesn't have any priors in it. It wasn't that bad of an evading, so.
All right, that is going to be dismissed by the state.
Yeah.
And James Frizzo. Frizzo.
Thank you for reminding me of it.
I meant to email you yesterday and remind you.
That's the one that's trying to get phone back.
Yeah.
And today, what are we gonna do today?
Let's get a plea.
Oh, all right.
Yes, sir. No, she did it. Well, I don't know if she can get through.
And we now call 25 CR 1495, the state of Texas versus James David Frizzell. That's you, sir?
Yes,
Correct. And you were here with your attorney and the state's attorney. Mr. Kelly, does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, we do, and we can, please, Judge.
In summary, sir, this indictment alleges that on or about December 12th, 2024 in Jefferson County, Texas, you operated a motor vehicle in a public place while intoxicated, DWI, driving intoxicated, as it's referred to. Paragraph 2 goes on to allege, though, that you have 2 or more prior convictions of DWIs. One on January 25th, 2007, out of McLennan County Court at Law. And that was in 2007. Also, that's weird. Later that year, you had picked up another DWI, or operating a motor vehicle while intoxicated, out of Collin County, Texas. Because you have 2 or more prior DWI convictions, every time you commit another DWI or operating a motor vehicle while intoxicated in a public place, it's a felony offense in Texas. So you were looking at a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. This is a third-degree felony. Do you understand? Yes. Respond, Jimmy. You can do it. Yes.
I'm sorry.
You understand?
Yes, sir. I interrupted.
Okay, good. Hold on. Let me work with the stylus. How are we doing on that? We get another one, or we're just going to be driven crazy with this thing? This one.
Just for a little bit longer.
Sure. But you don't have to be sequenced on DWS. Oh, no, prior to DWS. You don't have to be different issue. Yeah.
An agreement's been reached where you would be pleading guilty, found guilty. After being found guilty, you would be sentenced for what?
The agreement is for a 7-year probation, 10 years probated for 7 years. Judge. That's the
okay.
We negotiated.
All right.
I will say this, Judge, we put 10 days as a condition in there.
So
we
I've got
neglected
confinement in the institutional division of the Texas Department of Criminal Justice for how many? That didn't get filled in. How much time?
Confinement for 10 years, Your Honor.
And that would be suspended
for 7 years.
and then you would be placed on regular probation for 7 years.
That's right.
And fined $1,500. There would be terms and conditions of probation, though, that are normal and customary for DWI cases, which are special for alcohol and sobriety and operating motor vehicle responsibly kinds of conditions. Also, as a condition of a DWI third, you must serve at least 10 days in the county jail as a condition of probation.
Your Honor, speaking of the conditions, I'm sorry to interrupt the court.
Yeah.
We neglected to write ignition interlock in their plea paperwork. That was part of the deal.
I think
that's probably standard. It's probably standard.
That's always standard.
I just feel better about putting it in there, but
That's it's statutory.
You can't not agree to it. It's a condition of probation.
Okay. I just like put it in there. Thank you, Judge.
Okay. Do you feel better?
I do feel better when I put that in there, Judge.
I feel better.
We all. It was just looking over there. I see just a sense of relief.
It is.
After he said
it really is.
I'll feel better this afternoon too, Judge.
That's saying you're telling your sins to the priest. You feel better at the end of that. Some people. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes.
So how do you plead to this charge, sir? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
And paragraph 2, those prior DWI convictions, are those all true as they are alleged?
Yes, sir.
And are you pleading true to paragraph 2, those 2 prior DWI convictions, voluntarily, knowingly, intelligently, and because those are all true and correct as they are alleged?
Yes, sir.
All right. I'm going to show you, sir, what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered in. Without objection, it's admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All of this is true, so help you God.
Yes, sir.
State's Exhibit 1 is part of the record for all purposes. Pre-sentence report is waived here.
Yes, please, Judge.
I just want to ask you, James, this is the third one. What do you do? What are you doing to change what's going on here? I know you've thought about it, and now you're looking at going to jail, and it's a felony, and it's a felony for the rest of your life, you know?
Yes, sir.
So what are the next one would be a second-degree felony punishment, up to 20 years in prison.
Yes, sir.
Well, what are you doing to fix all of this? Which It's really, most of this is in your court.
Right.
What are you doing individually to make sure that this won't happen again?
I mean, obviously I've got to do something about my drinking.
Well,
And I've been
like
working
what?
on that, you know.
Well, they're going to help you,
Yeah,
but still,
absolutely.
at the end of the day, we're not at your house watching you with a video. I got you. Don't drink. It's going to be your choice.
Right.
What are you going to do about that?
Just not drink. I mean,
Okay, is that simple? I mean, can you make that decision? I mean, you're not, or is there some alcoholism or anything that prevents you from making the choice to do the right thing?
No, sir.
Okay. Oh, well, then fix this.
Right.
Okay. You got a lot to lose here. If family is at home, do you have a family at home?
I don't have a family. I mean, I've got mom, dad, brother,
Okay.
sister.
Well, okay. Well, but at the end of the day, you got you
Right.
too, and you don't want to flirt with more trouble here.
Absolutely.
Because this is, you touch the stove, it burns. Don't embrace the stove. All right. If nothing further, here's what I'm going to find. That you are pleading guilty voluntarily to paragraph 1 and true to paragraph 2, which constitute a third-degree felony of operating a motor vehicle in a public place while intoxicated, a third-degree felony. You are mentally competent to do so. You to make these pleas of guilty and true. There is sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt as you are giving up your rights to a jury trial and the rights to the appearance confrontation of witnesses. I now find you guilty beyond a reasonable doubt of this third-degree felony of operating a motor vehicle in a public place while intoxicated with 2 or more prior DWI convictions. I am following this agreement. You're hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That confinement will be suspended. You were placed on regular probation for 7 years. As a term and condition of probation, you must serve 10 days in the county jail. As a mandatory condition, you must pay a fine of $1,500. There will be other terms and conditions of probation. There are 36 of them, although most of these are conditions your attorney, me, all of us here have to follow. Don't commit crimes. Avoid bad habits. Don't associate with disreputable. Those are all good ideas for all of us. But we don't have a lot to lose like you do. If you fail, your probation can be revoked and you can be sentenced and go to 10 years in prison. And for DWIs, they kind of keep people in longer than normal. So you don't want that. All right. Also,
Page 4, just on after
where's the one for? Okay.
Yes, sir.
The additional, have an auto ignition interlocking system installed in your vehicle and complete the Texas DWI repeat offender program and pay associated costs. And those associated costs sting, but in the long run, it'll cost less by taking that and completing it than it would otherwise. You would have to, your insurance would go up sky high and other costs would be applied. And if nothing else, that's a deterrent to keep you from backsliding on this because these DWIs cost.
Absolutely.
They sting.
Yeah, I do. They're ready to go.
All right, and all of these are to help you complete the program successfully. We want you to get back on your feet and work. You got a job, I
Yes,
presume. Well, is it a responsible job?
I believe.
Yeah, you got people under you?
No, I don't have anybody.
But I mean, okay,
yes.
the people who employ you, do they rely on you? Then don't let them down. Don't let yourself down. You're better than this and you can do it.
Yes, sir.
Okay. 10 days in the county jail, when do you begin that? Well, how do you want to do that? Do you work during the week?
So I work a week on, a week off. I work on a tugboat.
Judge, may we do them from August 28th to September the 1st and from September the 10th to September the 15th?
Did you do your math, Tom? Did that come out to 10 days?
It's like 10.1 days.
Right. Hey, you've got a weekend and then 2 weeks later,
I think
right?
it's 4 and 6.
4 and 6. Now get the calculator, see if that comes up to 10.
For the first group and then 6 the second group.
Take it by Mr. Coleman's
High school,
silence.
in high school, interscholastic, first place in number sense. I won first place in number sense. So, yeah, it's 10 days. Okay, I'm gonna allow you to do that. It's awkward, but we work with you on this. We just want you to get it done quickly, move on with your life. Because nothing's happening. You're just vegetating in the jail and, get that behind you and move on and do great things. Your tugboat?
Yes, sir.
Okay.
Mute. What is it? Is it muting Wednesday? I mean, seriously. Like every place we've gone to, some judge is hitting the mute button. I'm kind of over it. Let's go to the board. The board never mutes.
What did I do? What? Something did you get? Damn. Good morning. This is the Committee on Parole. It's 9:14 on August the 12th, 2026, and our next remote location is at Allen Correctional Center. We'd like the staff at Allen to please introduce yourself for the record.
Assistant Warden Crystal Simon, just a manual classifications.
All right, and we have before us Mr. Wiltz.
Yes, ma'am.
So for the record, Mr. Wiltz, state your name and DOC number, please.
Darrell Wiltz, order 40768.
Okay. Well, Mr. Wiltz, we've been reviewing your record, and unfortunately today, because you received a write-up 2024, you're not eligible for parole consideration today. You have to be 3 years write-up free in order to be eligible for parole consideration. So unfortunately, it's very unfortunate because I know when you are granted parole in 2020, and I actually sat on that parole panel and voted to grant you parole. And then there was a time calculation error, I think, is why you seated where you seated today. And I was so disappointed to see the write-ups. I think we had 2 in 2024, which makes you ineligible today. So I think you got a little more time to spend before we can see you and consider you for parole again. You got anything you want to tell us?
Unfortunately, I apologize for the write-ups and I appreciate the opportunity. And, I have a little more time to, get myself together and.
Yes, good. I'm glad to hear you say that. So you, will he have to write back to us?
Yes.
When you're at the 3-year mark, which will be early next year, you have to write us a letter asking to be rescheduled for parole here.
Okay.
So right after Christmas, write that letter and stay right up free after that.
Okay, yes, ma'am.
Till then. Good luck to you, sir.
Thank you.
All right, that one was quick. Let's go back to Judge West.
Morning, sir. Joshua Smith. And so, Mr. Smith, before you came out, Mr. Lewis explained that some of the hesitation you have, that there's an agreement that you guys have worked out that you're willing to accept, but you're a little concerned because Harris County does things differently, I think, than we do. I just want to let you know how we do things. And then if you want to enter that plea, you can. If you want to go to trial, you can do that, okay? What I do is if someone pleads to an agreed plea, I do take that plea today, and then I reset your case for sentencing. During that time period, I have the probation do a pre-sentence report just so that I have more information when we come back. If for any reason at that time, there's something in that pre-sentence report that makes me say, you know what, I'm not going to follow this agreement. And what I do is allow you to withdraw your plea of guilty, and then we start all over. You go to trial or y'all work something else out. I'm never just going to give you something if I don't agree with what that is. That's not how we do things. So if that helps with that understanding, I'm gonna let you visit with Mr. Lewis again and go over that. But it's definitely I don't do that. I never have, and I never would do that. I don't think that's actually the right way to do it. So you're pleading guilty based on an agreement. And so if you don't take that agreement, or if I don't take that agreement, we'll start all over. Okay? All right, y'all go back and visit.
And that this has been kind of a weird show today. Short hearings, a lot of muting. Odd. Let's try the board one more time, and it might just finish our day out. Let's see how it goes.
Tell us your name and DOC number for the record.
Cleveland Ferguson, 193321.
All right, Mr. Ferguson, and let me just read some identifying information into the record, and then I'm going to turn it over to Mr. Freeman, seated to my right. Your case has been assigned to him. He'll take the lead.
Yes, ma'am.
Ready? Okay. So, Mr. Ferguson, you were your current sentence for 3 counts of armed robbery. You received a 60-year sentence. First degree robbery, 5 counts, 20-year sentence. That's running concurrently with the other one. And then 2 counts of simple robbery, you received a 7-year sentence. All that is running together. You were sentenced on July 18th, 1997. It's a total of 60 years. You have a parole eligibility date, which was August 1st, 2021, and you have a good time date in December of 2054. Is that information correct?
Yes, ma'am.
Right, Mr. Freeman.
Okay, Mr. Ferguson. How long have you been in there since your last revocation?
How
long have you been re-incarcerated? You were on parole before, and then you came back?
Oh, since 2015.
Okay, so you've been back in since 2015. Okay, tell me what you've done since 2015 to make me feel like you're a good candidate for parole.
I've taken 100-hour reentry, Boys to Men, Inside Out Dad, Thinking for a Change, Experiencing God, and Staying Right Up Free.
Okay. Have you taken any victim awareness classes?
Yes, sir, I have. I've taken Victim Impact.
Okay, tell me what you learned from victim impact.
To take responsibility for my actions and understanding the pain and discomfort that I caused other people for the crime that I've committed.
Okay. Okay. Tell me about that write-up in 825 that they took back, the fight. What was that about?
Guy that I was working with here at Allen, we had a misunderstanding and it just led to the fight. Actually, I didn't even fight back.
Yeah, and it was dismissed?
Yes, sir.
Yeah. All right, now tell me about the, in 2023, I see, well, it's 22 and 23, you had 3 contrabands. What was the contraband?
I had a cell phone.
Okay, both times was a cell phone for contraband?
One of them was I failed the drug test and they was contraband.
And then you have one intoxication also. Okay, so where are you gonna live?
The parole project have accepted me into their program.
Okay, Warden, what do you have to tell us about Mr. Ferguson?
Well, Mr. Ferguson's record speaks for itself. Mr. Freeman, he doesn't give us any trouble. He's probably one of our hardest workers around here. We keep him pretty busy, just doing things all around the facility. So that's all I can say about him. He's a good worker.
Okay, thank you, ma'am. All right, let's go on and hear from Mr. Myers at the Parole Project.
Good morning, Kerry Myers with Louisiana Parole Project. Let the board know that we're here for Mr. Cleveland Ferguson. As you heard from the warden and Mr. Ferguson, in the last 5 to 7 years, he's completed numerous CTRP programs, including living in balance, anger management, thinking for a change. He said that he's also, when he was at Angola, he had completed welding. He's also completed IC3 and ServSafe. He has continued to work there at Allen. He is a member of the SCA organization, which is a sports organization that also helps mentor the younger prisoners. At 56 years old, he is at an age where he's not only still employable, but at an age where recidivism is highly unlikely. Parole Project is prepared to offer him long-term housing, employment services. He'll be assessed by our social workers for any needs that would be related to any substance abuse referrals, and he would also have a mentor, a case manager that would work with him. Our employment team, again, he's at an age where he's very employable. He has skills. Mr. Ferguson is at a point in his life where we believe he's done with the cycle, and Parole Project is here to help support him through this transition.
Okay, thank you. I appreciate it, Mr. Myers. Okay, Mr. Ferguson, I do want to note that you have all law enforcement is opposed. You had one victim that's unopposed. A lot of them had no comments, and you did have one victim that was opposed. I'm gonna turn it over to my colleagues and see if they have any questions.
I got a question. You already been paroled one time on this case before, and you were sent to work release. Looks like you escaped from work release. You decided you didn't want to be there and take advantage of that parole. Tell us why you think this time would be different if we give you another shot at it.
I matured a lot since then, sir. At that time now, I wasn't thinking rational. I made bad decisions dealing with a relationship that I was in, which I'm no longer in. But at this age and this time in my life, I realized that I really need to get out and be a productive citizen. Boys to Men really helped me to understand that thinking as a teenager, a young man, I'm not that person anymore. I'm a much more mature person, and I want to get out and make myself a new life, be a productive citizen in my community.
Sounds like you're saying you jumped out of work release over to go meet a woman or something like that. You didn't really clear that up.
That was
why you left? Why did you leave?
I walked away from the work release center. This was in 15. It was on her birthday, and we had talked on the phone, and the conversation got heated, and our son kept hanging the phone up, and I just made the bad decision to leave.
Tried to walk back to Baton Rouge, huh?
Yes, sir.
I don't remember this case. Okay.
And the reason why it would be different this time is that you're older and wiser, basically?
Yes, sir. And I see life different. I mean, like I say, that was just a bad decision I had made in that relationship, and I'm not making no decision anymore.
Would put you back in work release, you wouldn't leave again?
No, sir.
All right. That was the only question I had.
So, Mr. Ferguson, I voted to grant you parole in 2015 to the work release program.
Yes, ma'am.
So confronted with that same situation today, how would you handle it?
I would handle it a lot different because, like I said, I think different now. If I was in that situation right now and there was a phone call and kid hanging the phone up, I mean, I just know now that to just let that be and continue to do what I need to do to be in work release center so I can finish the program, not allow anything outside of that to be my decision making.
You committed a lot of armed robberies back to back. It looks like you'd have had the police crossing you going from one location to the next. Why were you committing all of those armed robberies back to back like that? What was up during that time?
At that time, so I had a alcohol problem and I was on drugs and I had a gambling problem.
Okay, so what have you done since then to address those problems?
I've taken substance abuse, anger management, gambling is just something that I just chose just not to even but to entertain anymore. But I have taken courses of classes that help me understand how to deal with drug and alcohol abuse.
So how do you deal with it? What did they teach you?
Support when I feel like I'm going that drugs or alcohol is something I need to deal with a situation. I know that I can go to somebody and talk to them about it. Prayer. I mean, I'm a big believer in prayer, but to have outside support, somebody that I can turn to and say, well, look, I mean, I'm going through this and I'm feeling like I'm gonna go back to using drugs, or I'm gonna go back to using alcohol, just that support.
And who do you have for that support right now?
Right now here at Allen, we have a NAAA organization here, but with the Parole project, I've spoken with one of their counselors and they're prepared to have me placed with a counselor, somebody that I can turn to, and they was offering me to be in a group where I can find a supporter.
I'm gonna ask for an executive session, please.
Can I ask one more question? Mr. Ferguson, I see somewhere in my report that you were enrolled in GED or HiSET. Are you still enrolled?
Yes, ma'am, I am.
Have you tested at all?
Well, actually, I was supposed to take a TABE test today, but I haven't taken the actual HiSET test yet. I'm in night school and I'm working towards my HiSET.
Okay. All right. So we have a motion for executive session.
Second.
And I have no objection. So, Mr. Ferguson will be in executive session for just a few moments to discuss confidential matters. We'll be right back.
Thank you, ma'am.
Okie dokie. I have nothing else to show you. We are a few minutes in the Wayback Machine, though, so we're going to punch past this executive session and get the result and then call it a day.
We are back in regular session with no objection, and it is 9:36, and I think that we are prepared to vote. Mr. Freeman, it was his case, so he'll cast the first vote. Mr. Freeman.
Okay, Mr. Ferguson, you know, I looked at everything and that's why I took this break, because I ain't gonna lie to you, coming in, I had denied because of your write-ups, your intoxications and your contraband, in the last 5 years. I think that you should have been better, but we're gonna let you try to correct your own self. So what we're gonna do is we're gonna grant, but he has to complete conditional on completing his educational requirement, which is required by DOC. Then we're going to send you to work release again for 1 year.
Yes, sir.
And then we're going to send you to the parole project for 1 year.
Yes, sir.
So you're going to be closely watched for the next 2 years, okay? So it's up to you. You can either prove us right or you can prove us wrong, but you don't want to got to go back and do the time. So good luck to you, sir.
Thank you, sir.
I concur, same thing.
My vote also is the same, Mr. Ferguson. You've had, your record is concerning what happened in work release. I think you need to fix it. That's why we want you to go back and stick with it for a year. Warden Simon gave you some positive remarks, and you have a good transition plan with the parole project. So you got some things to accomplish. Good luck to you, sir.
Thank you all. Thank you.
Alrighty, friends, that's going to do it for this morning, but we'll be back in about 2.5 hours with second session, 2:30 p.m. Eastern, 11:30 a.m. Pacific, so do join me for that. Today's show was a little weird, but I hope you enjoyed it nonetheless. Our wisdom today from Plato: good actions give strength to ourselves and inspire good actions in others. So chew on that. Hope to see you in a little over 2 hours. In the meantime, have a good day. Take care. God bless.